Good afternoon, ladies and gentlemen. On behalf of the Bombay Chamber of Commerce and Industry, I welcome you to the 2 days legal conclave on emerging laws for emerging technologies. My name is Shruti Rathod and I will be your host today. To begin the proceedings, may I invite Mr. Sandeep Khosla, Director General, Bombay Chamber, to deliver the welcome address.
Thank you, Shruti. Good afternoon, ladies and gentlemen. A very, very warm welcome to each of you who are joining us for this very exciting and very interesting conclave, and which is very topical in nature as well. I would like to express my sincere thanks to our honorable chief guest, Sri Justice Sri Krishna, for gracing our conclave today. I would like to thank our esteemed speakers for accepting our invitation to address us today and tomorrow for these 2 day conclave. I would also like to thank our knowledge partner, Cyril Amarchand Mangaldas, and our supporting sponsors, which are Blue Dart India Limited and Blue Dart Express Limited and Hindustan Lever Limited, for the valuable partnership in organizing this conclave. With these few words, I would now like to request our President, Ms. Anjali Bansal, for her introductory remarks and setting the context for this conclave. Over to you, Anjali.
Good afternoon, everyone. Namaste and welcome to Bombay Chamber's legal conclave on emerging laws to keep pace with emerging technologies. Distinguished Chief Guest, Honorable Justice B. N. Sri Krishna, Shri Nilesh Shah, Vice President, Shri Bharat Vasani, Chairman, Legal Affairs and IPR Committee, our esteemed speakers at the sessions, ladies and gentlemen who are attending the conclave. On behalf of the Chamber, I would like to express my sincere thanks to our Honorable Chief Guest and also our esteemed speakers for taking time from their schedules and gracing this conclave. I would also take this opportunity to thank the members who have contributed to make this conclave happen under the stewardship and very able leadership of Shri Bharat Vasani. As most of you are aware, the Bombay Chamber, established in 1836, has a long and illustrious history of continuous service to trade and industry of 186 years. The Chamber in the last few years, and particularly in the last year or so, has had a particular focus on digitization, bringing startups into the dialogue with mainstream industry. And keeping in that spirit, we have seen that law and technology have long been in an evolutionary race, with generally technology leading by a significant margin. I am conscious that I am in a conclave of legal people, so I will not talk too much about technology leading the way. Instead, I will say that nowhere is this more evident than today, with the burning topics of the day being how do we regulate data, cryptocurrencies, online gaming, artificial intelligence, the ethics of artificial intelligence, who owns data, where is privacy, who is responsible, and who actually gets the benefit out of data usage. I'm very happy to say that over the next 2 days, we have with us the leading experts in these areas to drive forward a very, very important and timely discussion. I'm aware that you are all eagerly awaiting keynote address by our Honorable Chief Guest. We are so grateful and honored to have Justice B. N. Sri Krishna, and I request him now to please deliver his keynote address. Thank you.
Thank you, Anjali, for those kind words. It's now time for the keynote address. May I request Honorable Justice Sri Krishna to deliver his keynote address. Honorable Justice B. N. Sri Krishna, who has specialized in the field of labor and industrial law, has appeared in a number of cases in the High Courts and the Supreme Court, which laid down fundamental principles of labor law. His deep interest in philosophy, culture, music, and education made him a much respected figure in all music sabhas, religious organizations, cultural and educational institutions. He holds an MA in Sanskrit from the Mysore University, a diploma in Urdu, and a postgraduate diploma in Indian aesthetics from Mumbai University. He speaks at least 7 languages fluently. After being appointed as an additional judge of Bombay High Court from 1990, he was made a permanent judge in 1991. He has been invited by the University of Berkeley, USA, Bar Ilan, Israel, and Oxford, UK, to deliver lectures on socio-legal subjects. He was appointed as Chief Justice of the High Court of Kerala in 2000 and was appointed as Judge of the Supreme Court of India in October 2002, which office he demitted on 21/5/2006. He was appointed as chairperson of the Citizens Committee for Monitoring Security Issues in Mumbai by the Mumbai High Court. He was appointed by the Government of India as chairperson of the Committee for Consultations on the Situation in Andhra Pradesh to consider the demand for bifurcation of the states of Andhra Pradesh. He was also chairperson of the Financial Sector Legislative Reforms Committee appointed by the Government of India, which gave its report in 2013. Justice Sri Krishna headed the Committee on Framing Data Protection Norms set up by the Ministry of Electronics and IT. May I request our President Anjali to invite Justice Sri Krishna on stage? Anjali?
Thank you so much, Sandeep. Sir, over to you. Ladies and gentlemen, I give you Honorable Mr. Justice B.N. Sri Krishna. I've had the pleasure of hearing him on past events, and I cannot wait to hear what he says today. So thank you so much.
Thank you, Anjali. Thank you, Sandeep. Thank you, Bharat. Thank you, all friends with whom I have interacted from my bar days back in the 60s. And subsequently, I think one of the previous occasions also I had done 2-3 years ago, somewhere in the President Hotel or somewhere, if I remember right. Anyway, it's always good to be in the company of old friends. It's always good to interact with people who are knowledgeable and thereby get the benefit of their knowledge, learning, and wisdom. I have been asked to give a keynote on this subject. The subject is about emerging laws for emerging technologies in the organized by the Bombay Chambers Legal Conclave. I shall, of course, confine my attention to the technology of data, its protection, and all that surrounds it, but not from the technical point of view, but from a legal perspective. So let's go back and look at the wide canvas of data, its protection, and all the issues surrounding it. I do not know how many of you have seen the road known as Ray Road, which used to have a cobblestone all the way going from almost Vadala to the docks. As a child, I used to go travel along with my father in the car, and I would observe that there are a number of lorries exiting from the docks laden with food grains and constantly dripping the food grains along the road. So some kids would be running behind the lorry, picking up a broom and collecting the grain and taking it away. Now, when I was asked to head the Data Protection Law Committee, I was reminded of this, because this is precisely what happens in our life. We just go through life and our data keeps on dripping all the way. We don't even know its value till somebody picks it up and makes money out of it. Now, what is data? What is its legal definition? What does it really involve are some of the interesting things. They throw up very interesting jurisprudential concepts which need to be analyzed before we go into the nitty-gritties. Now, data basically can be defined as something that identifies a human being. Well, I'm talking only from the perspective of human beings, so that I will not talk about data having the ability to identify a non-human being also for the time being. Now, if that is so, my name could be data, my height, weight, and biological metrics could also be data, my address could be data, then names of my family members could be data, and so on and so on. Now, if all this is data, what is the value of data? Now, somebody has coined this sentence which has become very popular. They say data is the oil of the 21st century. Now, metaphors have limited value in legal analysis. Metaphors are good to broadly understand the idea, but when you break it down, the metaphor breaks down. Now, why does it break down? Is data really anybody's property? Now, the moment I have said it in so many public lectures, and people have said, "Oh, why you say it is not property, it is valuable?" I don't dispute that it is valuable. I'm only saying is it property. Because the only type of property, there are three types of property understood in law in India. One is immovable property, two, movable property, and the third is what is known as intangible property or IPR. Now, is it immovable property? Can't say that data is immovable property. Because by definition, immovable property is something that cannot be moved, it's fixed at some place. Is it movable property? Then the question that arises is, does it have the characteristics of movable property? What are the characteristics? Now, for example, my book, my pen, my clothes, my jewelry, all that can be movable property. Now, if it is movable property, jurisprudentially, and I am the owner of the movable property, I can sell it, I can create a charge on that, I can gift it, I can even destroy it if I don't want to. Can I do this with my name? Once you admit that my name is my data, how do I do it? Can I give it my name? Can I give my name to Anjali and say, please, Anjali, use it for the next 6 months and pay me 100 rupees per month? I can't do that. Therefore, the concept breaks down jurisprudentially when you apply it to something that is tangible. Then what is it? It is nothing but a matrix of intimate relationship between the person whom it indicates and the data itself. So my name indicates me, my age indicates me, my photograph indicates me. Now none of them is property in that sense. Then the next question arises, hey, when I say this is my data, does it have no value? I do not dispute that it has value, of course it has value. But please look at it, when you say it is my data, are you saying that you are the owner in the sense of owning a property of any kind? Or are you only saying that I have an intimate relationship with the data? If it is the former, then the jurisprudential concept will break down because now, for example, if I were to say this is my wife or my children or my uncle or my teacher or my friend, do I mean that they own them? I don't own them. The only time I remember in the Puranic event is when Raja Harishchandra was asked to own his wife and children and he had to put them on a mortgage because he had to pay the debt of Nakshatra. Now, apart from that, I have not come across anybody saying that I can sell my children, I can gift my children, or I can even destroy my children. So that concept breaks down. But when we come to the third aspect of property, namely intangible property. Now, law has recognized that there can be some property which is not tangible and yet it is valuable. For example, the intellectual property that you have of copyright, trademark, patents. Only difference is this: there was separate law made to recognize them as tradable communities, to recognize them as properties that are capable of being dealt with in any other movable property. Now, as far as data is concerned, first of all, there is no law in this country. The law is yet to come back. The concept is very much nascent. It has not really developed. Now, the pitfalls of accepting one jurisprudential definition as against the other are yet to be explored and repaired if found deficient. Now, in these circumstances, let us go forward with this concept that data only means some relationship between me and an indicator of myself, which is valuable. For what purpose? It is valuable because, now, for example, all of you are recipients of unwanted emails on the email. The email will say, I am prepared to send you this, that, and the other. Do you want this? Do you want that product? Do you want this product or this product? This keeps coming to us. It comes to, how does it come to us? I never disclose my email. Maybe my email was available on the Supreme Court directory. But there are some personal emails of mine which are not publicized, and yet I get them. My telephone number, at least the ones which I have not disclosed publicly, I still get calls on there. How do I get them? So some enterprising chap picks it up from somewhere and then makes money out of it by saying, hey, you want access to these gentlemen, these are the data available, will you pay me so much money and takes it. This is how it is monetized. This is the lowest level of monetization. There is more complicated than this. Therefore, data has value because someone who knows how to manipulate the data can monetize it and make money. This is the basic. Then the other issue is, hey, if it is my data, when I say my, please note, I am not saying I am the owner in the sense of the property being owned by me, saying that it is intimately connected with me. So when I say this is my data, can somebody just pick it up and start working on that and trying to make money on that? No. The basic bottom line is, you should at least have the courtesy to accept the data after my consent. You should come and tell me, yes, sir, I want this data. Can I take it and use it for this purpose? So the next bottom line is consent. Consent is absolutely necessary because it is mine and you want to take it, you must absolutely ask me. Had it been property in the real sense, also you could not have taken away my property without my consent, whether it is movable, immovable, or intangible. Having known all that, then the next question arises, is consent an absolute necessary or is it a sufficient necessity? There again, no problems. If you say consent is absolutely necessary, you will have various kinds of things. All of you must be walking into a theater, walking into a shopping mall. You will notice that there is somewhere a security camera, or walking into any building for that matter. There are security cameras in a hotel, restaurant, security cameras that take your picture. Now that picture is my data. Nobody can really technically take it without my consent. But then consent cannot be asked from all the thousands of customers who go into a shopping mall or a restaurant or a hotel. So the law assumes that the moment you enter into the premises, if you have known that there is a photo being taken, consent is presumed. There is an implied consent. So the concept is, consent is the basic one. Implied consent is when it is not possible. Now take for example, somebody may be knocked down by a truck on a public road. Now he or she needs to be admitted to a hospital. Now the hospital will want to know various parameters of the person, various details of the person. Now, he may or may not be in a position to give cogent answers, but even in such a case, there is presumed consent. Or let's say the hospital admits a patient and this patient is critically ill, they need some expert advice from some other bigger hospital, expert hospital with expert doctors. So the data has to be transmitted to that hospital, and at that time consent may not be a requisite, and without consent also it can be transferred. So much for consent. Then consent also has this difficulty of how can you consent with regard to persons who are not majors. Please note that all transactions of giving consent, giving data for processing is really a contract. And in this country, the contract says, right from Privy Council judgment in Mohoro Bibi's case, that consent given by a minor is invalid and such a transaction is void and will issue. Now the difficulty that arises is, Mohoro Bibi's case at the contract act of the 18th, 19th century. In 21st century, we expect our children to transact things on the internet. They have a number of websites which are useful, which expand the horizons of their knowledge. Now, if every time you insist that the consent must come from the parents, it will be impossible. So, how do you solve that problem? So, at what level do you draw the threshold and say, below this is the major, he cannot do it, above this is the major? That is another big issue that needs to be carefully scrutinized and solved. Then there will be a question of what happens if there is a security issue, the threat to external or internal threat, terrorist, chasing of terrorists and terrorist financing. These are matters where the state must be considered a paramount right to take the data of their citizens and residents without their consent. Therefore, that can be an exception to a consent. Or you could have a situation where data is given for processing. Now, please note, processing will involve a concept of not simply keeping it also processing or further manipulating the data for producing some other cogent results is also called processing. So either way, if you give data to a processor, how far it can say that this is the consent will work? Now I may give my watch for repairs, but let's take a bigger example. I may give my car for repairs. The consent is there. But can he thereafter say, I know car is with me, I will use it for some other purpose, I will go for a joyride, I will hire it out the taxi for 2 days and the car is supposed to be with me. In a situation like a car, that would of course require my express consent. But is this true in a situation of processing of data in the hands of the data processor is another question. Then we have issues like what should you call the person who gives the data, what should you call the person who takes the data? Now, all over the world, they had this data subject as the person who gives the data, and the data processor was called the data processor. Now, some of this didn't appeal to me, and I said that we have ceased to be subjects of anyone right from the time our country was liberated from the foreign yokes, and therefore, calling me a subject of anything is not. Therefore, if I am the person giving you the data, I am the giver of the data. You call me as a data principal, and if you are taking data on trust to process it according to my instructions, you should be called the data fiduciary. Fiduciary is an expression that is used very much in law. Anyway, with all this, let me last thing about consent, and then we move on to some other concept. Now, consent, in order to be valuable and legally enforceable, must be what they call informed consent. That means all circumstances attendant upon the transaction must be made known to me, and then only can I be said that I have consented. I don't know how many of you remember that when SEBI was in its nascent stage, I used to have mutual funds being advertised on the TV, and they would say some government book in 2 months, 2 seconds, and then you were supposed to understand it. SEBI came down heavily on them and said, hey, if you are making this kind of a proposition to a person who is watching the TV, it should be done for a minimum of so many minutes in a manner of this speed and not anything else. The idea is that the person should be informed of that. Now, once you talk of informed consent, you have infinite number of difficulties in our country. Now, if I were to go into some place in Tadoba or in Ichalkaranji in Maharashtra or say Pattanamthitta in Kerala or somewhere in Tirunelveli in Chennai and start talking to them in English, well, perhaps they may understand, they may not understand. But are they informed, as the law has called it? The information has it been put across to them in a manner to understand it. So it may not be possible. That is why we have state languages, local languages, and all these problems that arise. Therefore, the information has to be conveyed in a manner that is understood by the recipient. Now, what do? There is a large section of our country countrymen cannot even read and write. So, how do we put it across to them? So, in such cases, it may be necessary to put across the pictorial representation. Like, for example, you see no parking boards, pictorial representation, no smoking boards, a cigarette with a cross, a poison, you have a bottle with something and it says a skull and crossbones. This kind of pictorial representation also is possible and it should be done in a manner of getting informed consent. Now, this is all with regard to consent. Then we have issues like, hey, I gave consent. Now, let me give an example. I bought a plane ticket of a particular airplane company, and I was supposed to go from Bombay to Chennai, let's say Mumbai to Chennai. And next day in the evening, even before my flight was to start 1 week later, next day in the evening, I get an email from some sari shop in Madras or Chennai saying that they offer this kind of saris at discounted and some Tangamali guy offering gold ornaments and all that. I say, well, how did you get into this situation? How did you find out the data that I was given by me to my travel agent for getting a ticket? Obviously, the travel agent must have passed it on for some kind of remuneration. Therefore, the next question is what is known as a purpose limitation. If I gave data for X purpose, you can't use it for Y purpose without my consent. This is one of the fundamental assumptions. Then the next question is, suppose I happen to give the data, how long can you hold on to it? Now take for example a simple example I always give. I go and open an account in a particular branch, and 6 months down the line I find that the service is used for useless. Can't I close my account? And of course I have a right to close the account. Once I close the account, what happens to the data that he has put it in his computer? So is he entitled to carry on with it? So I have a right as a data principal to say, hey, the purpose of giving you my data will include all kinds of things. It will include my name, address, telephone number, mobile number, email address, and then financial details, etc. My purpose of giving it to you was to help me operate this bank account for my financial transactions. I have decided that I am going to wind it up. So why should we carry on my data? Therefore, this generates a concept of purpose limitation as well as the right of the data principal to seek deletion of the data. Now, how many of you, I do not know, possess ration cards? But whoever has applied for a ration card will always find that the name that is shown on the ration card is gobbledygook and never tallies with the actual name of the person. Thank God now Aadhaar is very clear about it, PAN cards are very clear. I'm talking about the days when we didn't have both. Now, what happens in such a case? I should have a right to go back to the person to whom I have given the data, maybe the rationing officer, saying that, hey, you are maintaining my data, including my name. Please have the spelling corrected. Please having the address corrected. Please having the age corrected. Now, my age may be 80 and I may be shown as 16. I mean, it's very complimentary for me, but then that doesn't help in legal relationship. Therefore, it is necessary that there should be a right assumed and invested in the data principle to have the data rectified, kept its integrity maintained, and also the right to have it deleted. Now, when you come to delete it, there is a little problem there. Supposing I were to go to the bank after 6 months and say I want to close the data, delete all the data on your records. He will say, sir, unfortunately, the Income Tax Act requires me to maintain all my records for a period of 7 years, otherwise they'll reopen my assessment. Therefore, I must maintain it. Yes, that is the correct position. You can ask for deletion of data unless it is required by some legal provision to be maintained for a specific period beyond the purpose for which it was given. Now, so much as purpose limitation. Then you have concepts like cross-border transfer of data. That has raised a number of issues as to whether the data can be freely transferred. Should it be kept inside India or it's outside India on a server? How does one access it if it is outside the country? What are the methodologies? Now, the methodology that is generally available is, now, one thing is sure, no court in India, no policeman in India, no government authority as in India, however powerful in India, will not get the same privilege when he crosses the border and goes to a foreign country. Now, let's say that I'm maintaining, this will be a problem that will affect mostly MNCs. MNCs have their data, let's say it's kept in a server in California or Timbuktu or wherever. I'm assuming California for the time being. Now, the company will be operating from a place in India, maybe in Mumbai, Madras, Delhi, wherever. So, if it becomes necessary to access the personal data of the persons whose data is being collected by the company, and if after a proper executable warrant, an authorized officer goes and says, I want this data because I think he's a terrorist or whatever the reasons are. The person in charge here will say, sir, but it is not in my pocket, it is on some server in California, I can't get it from here. So if you try to access it, it will have to go through the whole mechanics of the Indian government, then the Indian Judicial Authority, the Indian government, the diplomatic voucher probably, and then go through the same process down the stream in US, come back the same way. That is why they have what is called Mutual Legal Agreement Treaties, MLAT, Mutual Legal Assistance Treaties. Now, the MLAT is obviously for good reason, very slow process. It takes about 18 months to 24 months to produce the result. But in the meanwhile, if you are chasing a terrorist, you can't wait for him to wait for 24 months. Therefore, a situation has to be found out of how to access it for good reason, for legitimate reason, for legal reasons, then and there. Two methods are possible. One is that the person who maintains the data should be called upon to maintain it within the jurisdiction in India on a mirror copy, updated information, so that it is available wherever else he may have it. Or in the other alternative, if he has some difficulty in doing that, he should give an undertaking that when called upon by a proper authority, a proper authorized officer, a proper person with a warrant, that he will produce it within the specified time limit, within 24 hours or 48 hours or whatever the law will permit. That is one way of solving the problem. Now, this is the one that is called popularly data localization issue, and which has created some kind of tension between India and several of the Western countries. Now, one more issue which arises in connection with this is what happens when data is transmitted from, let's say, from India to some other country. Now, there was an interesting case. There is what is known as the adequacy test. Adequacy means that the country to whom you are sending should also have the same type of data protection which is available in our country, and then only it will agree to permit you to do it. Now, there was this issue between companies operating in US and across the Atlantic in Europe. Europe has very strict data regime. Now, they had entered into an agreement called a data shield. Under the data shield, data was freely transferable between two entities which are parties to the data shield agreement. Now, somebody challenged it in Europe, and the European court came to the conclusion that the data which was transferred to US was easily accessible to the federal authorities on a mere declaration by the president, and therefore it did not meet with the adequacy test and struck it down. Now, that is an issue that needs to be carefully considered, and I hope that Parliament will really look into this issue so that we don't get into such a difficulty later on when the Act becomes operative in India. Then, fine, all these concepts are good. So, who is going to monitor it? Therefore, the idea is to have a regulator, like you have a regulator in the banking operations called the Reserve Bank of India, in telecom, the TRAI, in capital markets, the SEBI, insurance, you have the IRDAI, and such a regulator should be available. That regulator will be called Data Protection Authority. He will have jurisdiction all over the country. He might have regional officers in each state, and his job will be ensure that he will interact constantly with different sectors of industries, ascertain their best practices, and also come out with regulations which will, the best practices which will later on be turned into regulations after a lot of give and take. That way, the data processing will continue to be monitored by the authority. It will also be the job of the authority to ensure that there are no data breaches. And if there are data breaches, what is the protocol by which it is to be reported? What is the period within which it has to be reported? And what are the consequences of that? There will be some adjudication possible. There will be an adjudication officer who will adjudicate if there is a data breach, what are the consequences, what are the reasons for it, and then appropriately levy some kind of compensation by way of monetary compensation. Then one interesting thing which is really causing a lot of problem is that this law is intended to apply across the board to all private entities as well as the government departments, all public authorities. Now, there is always some kind of a tension when such a thing is done. The government doesn't usually want itself to be bound by it. So there is some kind of a drawback on this, which is being considered by the JPC and probably considered by the Parliament also. Now, the next question that arises is, now, for example, sorry, I forgot to mention this, that when we talk of data localization, today there is no law. Please note, there is no law. And yet, two of our regulators, namely the Reserve Bank and the TRI, have already shot the gun. Both have said that Reserve Bank has said all financial data pertaining to Indian operations must be maintained on a server in India. That is data localization in the strictest form. Similarly, TRI says all mobile data originating in India or terminating in India must be maintained on a server in India. So two of the regulators have already shot the gun, and I do not know how the law is going to take into account these two regulators and deal with them. Then there are several other issues which need to be considered. For example, what happens to historical data? Historical data, can it be? I told you that there is a right of deletion of data. Rate of deletion of data gives rise to all kinds of problems. Now, somebody may come to me and say, hey, last year I was accused of theft. I was tried, held guilty by the lower court, and then subsequently acquitted honorably by the High Court or the Supreme Court. Therefore, would you be justified in saying that whatever happened in the trial court by which I was convicted, that conviction order must be removed from the books of law books or law reports? Is that justifiable? Is that really the intention? Is that a debatable issue which needs to be considered? Then finally, now comes the interesting part. Why is there so much valuable data? How does it help citizens of this country at all? Now, data has become all-pervasive today. The reason is this. There is a fundamental assumption in human life that past events will help you in predicting a future event. Why am I saying this? So if a person has behaved in a particular manner in the last so many years, that gives rise to a pattern, and it is expected, all things being equal, that same pattern will repeat. So how do you put this in practice? Look at the rain pattern. Oh, in 20 years, this is how rain has come. These are the areas which are dry. These are the areas where there is excessive floods. Therefore, you can get a pattern. Or with regard to analysis of epidemics, now take for example the famous one that is going on, COVID and Omicron and Delta, Sigma, whatever that comes out. That how do you deal with it? What is its breakdown region-wise, sex-wise, age-wise, then other parameters, profession-wise, or conditions of service-wise, comorbid-wise, and all this can be broken down. Now, all this requires what is known as a statistical analysis. A statistical analysis. Please note, statistics is not an exact science. People may tell you that, of course, there is a very famous saying that there are three kinds of lies: lies, bloody lies, and statistics. Now, I don't support that theory because I happen to have studied statistics. Statistics is a good indicator. Now, if I have lived healthily up to this age, and I don't have this kind of habit, that kind of habit, or this kind of comorbidity, that kind of morbidity, one can presume that I will continue in the same fashion if I keep in the same parameters for the next so many years. That is how insurance companies operate. But how does the insurance company know that I'm going to live up to 50 or 100? He looks at what has happened, what my habits are, whether I drink, smoke, or I'm a drug abuser, whether I regularly exercise, or I'm a lethargic person. And then he comes out with a solution and says, okay, I assume that that I will not be called upon to pay your liability up to this age, so he reduces the premium. Now, take for example, Mahalakshmi race course. How do the persons work there? They look at the horse's pedigree, how many races it has won, how many jockeys, who are the jockey who was riding it, what is his history, and then come to a conclusion and say, well, if this horse runs in this race, it is likely to win, and they bet on that. How does the stock market operate? I'm sure all of your members are stock market operators. I don't have to tell them how it operates. Now, this can be analyzed, How do lawyers predict that which judge will behave in what manner on what date? This is precisely how they do it. They watch the judge every day and look at him. how he behaves, and how it's not surprising that some judges are called pro-labor judges, pro-employer judges, then pro-prosecution judges, pro-accused judges. Why? Because of the pattern. So statistical analysis of repeated events gives you a pattern, and that pattern is a very crucial index in indicating what will happen. Now, this is very important from the point of view of collection of data. Now, therefore, data has become a very important event in our country because we have realized at last the potential of data and the gold mine on which we are sitting. Now, healthcare needs data. Now, healthcare would mean what? An analysis of the different types of health facilities we have, how we have been able to meet in the past, what is the likely event that is going to happen in the next foreseeable future, how do we meet it, what are the circumstances under which will not be able to meet it. This kind of a foretelling is absolutely necessary from the healthcare point of view, but this will not be possible unless you have sufficient data in your hand. Please note that the larger the volume of data, as they call it in statistics, they call it the sample, the larger volume of data, the more accurate will be your prediction or looking into the future. Then you have payment systems. Today in the digital world, payment system has become almost, thanks to the COVID for last 2.5 years, everybody has been doing only payment system, using payment system. A payment system cannot operate unless you have accurate data available from end to end. Of course, end to end it will be encrypted, that is another matter. So that is absolutely necessary. Then travel. Something interesting. On a given day, you have an airport like Mumbai, or even an airport like Heathrow in London, or New York, JFK in New York. How many flights are coming in? How many flights are going out? This is an actual data that is necessary in order to plan the airport. If you have an airport, expand the facilities in the airport, or even start a new airport like they are doing in New Bombay or in Jawar in UP. Therefore, this is necessary, and the travel agents, the booking agents, they require a whole lot of massive amount of data. They churn it and come to some kind of an operation that is feasible. Then the next question that arises is, how do you maintain the integrity of the data? One of the biggest problems like data, or for that matter water also is, like all reservoirs, how do you ensure that the water is not leaked out? How do you ensure that the water doesn't evaporate? Similarly, with data, how do you ensure that it is not leaked out? That it is not unauthorizedly accessed. This is the biggest issue that is facing the world today. Now, in America, we have all kinds of things like phishing attacks, then ransomware, and then carpet bombing type of attacks. These kinds of things are there for what purpose? For the purpose of either immobilizing your data so that you have no access to it, or for taking away your data so that you have no access to it. Therefore, this unauthorized access to data, which is valuable from your point and from the point of view of the hacker also, is another issue that needs to be carefully considered. And of course, the biggest challenge or the biggest customer for data today is AI, artificial intelligence. Artificial intelligence requires massive amounts of data, and the bigger the volume of data, the more accurate is the algorithm that will be found out to make the computer do what you want. Now, with data, you can do Chandrayaan, you can do Mangalayan, you can do Budhayan, Shukrayan, everything Ayan. You can run, you can effectively patrol the borders of the country. You can effectively run ships across the ocean. You can effectively run planes across the skies so that they are not in any way a danger to each other. Artificial intelligence really governs it, and soon we might have AI-driven automobiles in this country, and hopefully that will reduce the number of vehicular accidents that we read in the newspaper almost every day. Then, what has been done with regard to this entire branch of data protection in this country? Now, I must say something here. I've been advised that I should not call a spade a spade. I should call a spade as a gentle digging instrument used in the garden. I shall follow this advice and I shall continue to call the spade a gentle digging instrument used in the garden. Now, there has been attempt made to protect data. Why was it necessary? Let me give you a little bit of historical background, then we'll be able to understand why it is necessary. You see, if you go back in history, and I don't know how far you want to go back, people think that data is something that the Westerners invented and told us about. Certainly not. Way back if you remember that famous Vishnu Sharma's advice to the king's sons, he was given in the Hitopradesha. He says, Ayurvittam Grihachidram Mantram Aushadhamaithune Danam Manapamanaucha Navagopyani Gopayat. He said every human being must keep confidential and private 9 elements of his data. What are they? Ayu, his age; Vittam, his monetary wealth; Vittam; Grihachidram, his domestic problems; Mantram, whatever mantra he has received from his guru, he should keep it for himself, not go around talking about it. Aushadam, the medical advice that he gets, the medicine that he is consuming, medication that he is utilizing, that should be kept confidential. Then Maithuna, his sexual affairs, he should keep it for himself, not talk about it in the gossip columns. Then Dhanam Manapamanocha, the charity that he makes, the insults that he has to suffer, and the encomiums that he gets from others, these are all matters to be kept confidential. This was way back in, God knows, in the 5th century, 6th century, something like that. Now coming down rapidly to the 19th century and 20th century, we found that in India too the issue had arisen. Now the issue arose in the initial stages because of what is known as police monitoring or police surveillance. There was this fellow whom the police suspected to be a criminal or indulging in some criminal activity. So constant surveillance was mounted on him. So he challenged it before the High Court and said, hey, this amounts to my data being, my privacy being infringed by these persons, privacy is my right, etc. So the court accepted it. There was another case, I think it was in Madras High Court, if I remember rightly, that there was a case of a prospective bridegroom's medical problem being disclosed to the prospective bride's parents, as a result of which the alliance did not come through. Now, whether that could have been done or not became an issue, and whether it amounted to infringement of privacy right was also considered. So these kinds of small things went on there, and the courts took contrary views, sometimes saying yes, sometimes saying no, and all that. The crux of the issue came when the government of India introduced the Aadhaar. Aadhaar, as you all know, was initially a department of the government. Then it was spin-off department, but still a department. There was no law on that. And somebody challenged it. Somebody is another compatriot of mine, Justice Puttaswamy. He challenged it on the ground that it amounts to violation of my right of privacy, which is a fundamental right. When the matter came before the court, one of the issues was Aadhaar is an infringement of the right of privacy, which is a fundamental right. The court rightly asked the question and said, how do you say it is a fundamental right? So that became an issue. So they had to go into it, and after 9 judges, I think, went into it and produced a 1,500 paragraphs or 1,500 pages, I forgot, judgment, which ultimately said fundamental right, right of privacy is a fundamental right, and every citizen, every individual in this country has the right to be left alone. There is a lot of spin-off from the fundamental right issue. Now, when this was being done, even before the judgment had come and the matter was being argued, I remember that it was a Friday evening and I had just finished some other issue, and then I was about to catch a flight and go to New York. I got an SOS call from the minister, then law minister, saying that we are going to constitute a committee which has to examine the contours the law about privacy in India, data privacy in India. I wanted to be the chairman. I said, okay, and then things happened. Then I learned that the urgency with which they wanted to constitute the committee was because the Supreme Court was asking them one fundamental question. You are talking of privacy right, but where is the law which gives you the right? So that was some kind of the law in this country needs to be examined. So ultimately, the government appointed the committee made a report, a draft bill which went into substantial variations in 2019, then again the JPC, and ultimately it is pending in Parliament. JPC, I'm told, has made a report, and as they say in the Bollywood advertisement, Baki ka parde par dekho. Now, what contours it will take is not something that I'm going to speculate upon. I will just say that these are all the issues that need to be considered. And then there is one aspect of the matter which needs to be carefully considered. That the first report, the bill, and the first bill, 2018 bill, were all called Personal Data Protection Bill, PDP. Because it is the personal data which has been declared to be a right and fundamental right emanating from Article 21. Now, if some right emanates from Article 21, it is established law by a series of judgments culminating in Puttaswamy judgment that it cannot be taken away or infringed or abridged except by parliamentary legislation. It cannot be done by executive orders. It cannot be, there should be a declared objective which the law must definitely demonstrate to be achieving. And finally, the law has to be proportional to the evil that is to be avoided. Now, these triple tests that the Supreme Court has evolved latest in Puttaswamy will have to be applied to any law that Parliament makes, and in order to sustain its constitutionality. Now, the one is strange thing according to me is they have coalesced what is known as personal data with non-personal data by one enactment, which is now called Data, I don't know what it's called, Data Protection Act, is it? Without removing the word personal. Now, what kind of complications it gives rise to? How do you stop the demarcation of personal data and non-personal data? Because one is fundamental right and the other is non-fundamental right. How do you determine this is going to be some kind of a problem? I do not know how the Parliament is going to solve this problem. And as and when Parliament enacts the enactment, I would like to take a look at it and then understand how it has been done. So I will not bark up the tree any longer and leave it at that. Then there are other issues which have arisen as a result of data protection. The data protection has a direct impact on what you call the e-commerce. Now, how does the e-commerce work? How it regulates the business? How much of it is capable of being controlled by the government? Whether e-commerce will be subject to the Competition Commission's jurisdiction? And what are the implications of e-commerce companies having transnational business relationships? How far is the Reserve Bank's control over foreign exchange going to impact it? These are all open issues, and it's something that needs to be carefully studied. Then you have regulation of, you have interesting things like regulation of online gaming. Recently, we had the Madras High Court judgment. We have had earlier also the Madras High Court judgment in earlier case, also in Lakshmanan's case, saying that what is the difference between online gambling and an activity of exercise of skill. Now, how much of that can be done online is another issue on which there is no clear-cut authoritative pronouncement, except that the courts have given a broad line indication that if it is skill dominated, then it cannot be controlled by, it cannot be called gambling. And if it is chance dominated, it is not skill. Now that is something that have to be taken care of when you talk in terms of online activities governed by Data Protection Act. Then healthcare, telemedicine, e-pharmacy are also going to be impacted by this because there is already a database setup of health issues. Now, how much of that is within the parameters of the act or not will have to be tested only after the act is made available and then somebody looks into it carefully. Financial regulation is already going on, and the latest one to be added to the financial regulation is cryptocurrency. So, how much of data privacy issue does cryptocurrency regulation throw up is something to be decided after we see the law in position and then see how much of comes within the whether it can be banned, whether it gives rise to issues of data security, it gives rise to issues of data protection is another issue that will have to be carefully monitored. Then of course you have social media platforms, then media platforms which have brought in content and they are distributing TV and ad companies, how they are going to be affected by the control of the PDP bill because of the overriding provisions there is something that needs to be carefully monitored. Then one thing is sure that having recognized the potential of data, there has been an attempt made to harness it for good purpose. I mean, it's something like this. A stage was people did not know what was electricity. Then people invented electricity or discovered electricity, depending on what view you took. Then they said, hey, this is good for us. We can use it for this purpose, this purpose, this purpose. Similarly, when invented nuclear physics enabled us to see and harness the potential of nuclear fusion and fission. Then that gave rise to a whole lot of issues. Control, what kind of control should be there, whether it's the control against security of the establishment, whether it's control against harmful effects of radiation, and those debates are going on. Chernobyl and all that has been Fukushima, Chernobyl we have seen in our own lifetime. This will go on. Now, these are some of the issues that need to be carefully monitored. And one thing is sure, there cannot be, as they say, the perfect is the enemy of the best. Under the given circumstances, what is best for managing our country should be our motto. Now, it may be that GDPR is good for Europe. Some of the ideas in GDPR are good for us. Now, is it sufficient for us to just blindly copy GDPR, or is it necessary for us to modulate it to meet our circumstances and carry on with it? Is an issue on which every Indian is entitled to his voice, every Indian is entitled to his vote, and the country as a whole has to take a call on that. That is a matter of broad policy. Hopefully, within the next couple of months, we should be able to see the policy being crystallized into some kind of a law, and hopefully that law will pass muster. Hopefully that law will pass the constitutional rigor that is postulated in Puttaswamy, and hopefully we will all be very happy in the future. Thank you very much. My thanks again to the Chamber of Commerce, the persons spearheading the conclave, Anjali Madam, Bharat, Vassani, Mr. Kapoor, and everyone who is present here. Thank you very much for giving me this opportunity of exchanging my ideas with you. Like you, I am also very keen to see what is going to happen in future. Thank you very much.
Justice Sri Krishna, on behalf of Bombay Chamber of Commerce and the Legal Affairs Committee of the Bombay Chamber of Commerce, we can never thank you adequately for this very erudite and very comprehensive opening keynote address on the law, which incidentally and so coincidentally the report is tabled in Parliament today. So hopefully the government cannot go back on it now because it's already tabled in Parliament. And we would see the revised draft of the bill. They say they are making some 150 corrections. Justice Sri Krishna, I have always wondered, right from you started your career before the Bombay High Court in your 20s, advising on diverse range of matters, then getting elevated to the judge as a judge, and then moving to various high courts and finally in the Supreme Court. And thereafter, your most active life post Supreme Court retirement, have you kept account of how many legal opinions you have issued, how many arbitrations you have awarded, how
Honestly,
many
no.
committees you have presided, how many committees you have presided?
Committees, yes. The number of committees I can remember, it's about 7 or 8, not more than that. But how many opinions I've rendered, how many judgments I gave, I can't keep track of that. I'm sure, of course, and the judgments would be there somewhere in some law report, but opinions are not kept count. And sometimes people come to me and say that you have given an opinion like this. I say, what party's name is this? Then I say, vaguely I remember it. Show me the opinion. Let me again recollect it.
But sir, I can tell you it will go into Guinness Book of World Records. No judge would have presided over such a vital committees, right from Bombay riots till Andhra Pradesh subdivision and one financial regulation commission.
Yes,
I have always seen you. And second thing, what impresses me the most that not once I must have heard hundreds of your speeches. Not
yes.
once I have found that there's 1 minute which we can even, it was not interesting enough. And in such a short time, you have covered virtually the entire gamut of issues which will arise under this Data Protection Authority and Data Protection Bill. And let me tell you that this new law, the way it is drafted and the way the issues are there, you may have to issue as many opinions on this new law as you have issued so far.
I will tell you, Bharat, I will tell you, uh, as soon as the insolvency and bankruptcy code came in, my time was taken up every day on that one. This section, that section, and then my opinion gave rise to 2 amendments, the 28.
But
So
sir,
probably it happens here also, I think.
Bombay Chamber of Commerce and Cyril Amarchand Mangaldas both are so proud that you've been part of this and you made these opening remarks, which were so interesting. And we'll be seeing now the bill which is tabled in Parliament and
Yes.
see how far it will meet the test of Puttaswamy judgment, the Constitution Bench judgment, and I suppose there will be some litigation. So my biggest challenge, as I see, is that the Data Protection Authority will become even bigger than SEBI in terms of framing the delegated legislation under it, and vast number of rules and regulations that will be framed to implement the provisions of this act is going to be very interesting. So next few years, all the lawyers are going to be devoting significant part of their time in understanding and studying the new law and all the regulations framed thereunder. So, on behalf of the Chamber's Legal Affairs Committee, we would like to sincerely thank you for providing your opening remarks, which are in fact very, very comprehensive. And you touched upon some of the other aspects also, which we are going to deliberate over the next few days. Thank you very much, sir. And I would now request you to join the panel discussion, moderate the panel discussion, which is there with Arun Prabhu and others. So, I would request the Bombay Chamber to put up the panelists on the stage and we can start the panel discussion immediately so that Sri Krishna is a hard stop at 5:30 or so, but we need to stop. This is the second panel also
Oh, sorry,
afterwards.
Bharat, that 5:30 hard stop also can be cancelled because I just received some email saying that that event has been cancelled.
Oh, very good. So we will have your advantage of your presence for much longer. So I would request now DG Khosla Sahab and Arun Prabhu and others to kind of take over and commence the proceedings of this panel discussion, which will be moderated by Justice Sri Krishna. Thank you very much, sir. We can never thank you adequately.
You're welcome. I must thank you because you keep me active.
Okay, fine. Yeah, good afternoon. And as Bharat Bhai said, many thanks to Justice Sri Krishna for such a wonderful address. We practically covered all the aspects which you've been dying to listen to. So thank you, Justice. And may I invite you back again for the panel discussion, which is the role of data in regulation of technology. Moderator, Justice B.N. Sri Krishna. And along with him, I would like to also invite our panelists for this session, Mr. Keshav Dagat, General Counsel, Microsoft India, Mr. Harish Narsappa, co-founder, Daksh, and Mr. Arun Prabhu, partner, head, TMT, Sri Lankan Mangalas. Hi, Arun, good afternoon. Hi, Keshav, good afternoon. Good afternoon, Harish.
Harish.
Hi.
Good afternoon, Glenn.
Yeah, and for our moderator, Justice Krishna.
Arun, perhaps you should start while we wait for Justice Sri Krishna.
Sure, Harish, and let me start off by just congratulating our speaker, Mr. Harish Narsappa, who was designated Senior Counsel by the Honorable Karnataka High Court yesterday. So it's a great occasion to be speaking on this topic today, which is the role of data in the regulation of technology. Even as we were coming on stage, official copies of the variant of the Personal Data Protection Bill, or now just the Data Protection Bill, as put out by the Joint Parliamentary Committee, have started doing the rounds. There is a press release which makes for somewhat interesting reading, indicating that there are in excess of 100 changes which have been made as by way of correction, and there are substantive changes which have been made across multiple topics. And while obviously following on after the author of at least some variant of the bill is always a very tough task, I want to try and anticipate at least one question which Justice Sri Krishna would likely have posted to us, and see if we can kick off the conversation with that. And I'll start off with you, Keshav, and as heading the thought leadership on the balance.
Losing you, Arun. I cannot hear you.
No, we can't hear you, Arun.
Arun, we couldn't hear you.
Sorry, am I audible now?
Yeah, now it's good. Yeah.
Great. Keshav, so I was saying, as being a thought leader on the balance between law and technology, and one of the leading technology innovators in the world for the last several decades, being at the forefront of a company which specializes and focuses so much on artificial intelligence, just what is the role of data and the regulation of data when it comes to technology and innovation? Would love to hear what you have to say on this.
Thank you, Arun. First of all, it was definitely humbling to hear Justice Sri Krishna himself sharing his wisdom. But I think, as you said, the way he captured, just the developments and the technological advancements the country has seen was just very inspiring. And of course, the journey started with Justice Sri Krishna. So here we are, almost on the verge of having a new regulation, which I think we welcome with open arms. It's going to truly transform the way individuals' rights will see a whole new level of protection and empowerment. we will see the business practices undergoing tremendous amount of changes, all for the good reasons. While regulations are seen as a disruption or as a burden, I think when we start to look at regulations in a positive light, we have to see that they are more enablers. They are the ones who shape the industry. And we have seen that happen in telco or the banking and various other regulatory environment that actually develop confidence between the consumers of the services versus service providers and the role of the government in being the arbiter and the regulator side of it. I think you rightly mentioned the balance that we will want to see in the upcoming regulation would be actually across how does the law takes care of the concerns that government had as they look at the individual rights, but also how they were thinking of responsibility and accountability of the data processors and controllers in a way. And I think we will see the business practices, but also the view towards data was going to change fundamentally, because data in any case is limitless. It is being generated at a pace we have never seen. Right? It is wrongly being treated as the new oil because data is limitless, not finite. And when you think of 2025, we will have 75, 76 zettabytes of data, and it's going to continue to grow. And India is already becoming a huge data producer. So this is the right time for us to really bring our first privacy legislation. While privacy has been recognized as fundamental rights, a human right, we treat it as a human right that we all have to. So as a tech provider, I think we have to see very holistically the role of technology vis-a-vis data, vis-a-vis regulation, vis-a-vis policy, and how do we really bring a balance to all. And we believe that privacy is something that it talks to, and including security, that talks to the responsibility and accountability that rest with both the users, how they use their data and how they share the data. Secondly, those who receive data and those who process data, and those who kind of use data. And we will see that this is going to fundamentally change the way data governance will shape up in businesses. Data is already becoming a kind of a core asset for every organization to harness its potential, to leverage AI on top of it, and that data is actually defining what digital transformation journey is. So we will see privacy and control coming together. We will see that that privacy is also about what controls does a consumer has or an individual has when he or she accesses any service, right? Or when he or she shares data. Also, they would want to know who has access to my data, right? And what kind of controls do you have, and are you transparent enough to share what access you're giving to others who are looking at my data? Then it comes the fact that are you mining my data for advertisement purposes, which was not the purpose for which you collected the data, right? And the consent will play a role, including so much so the third-party request, which could include a law enforcement asking for data for legitimate investigation purposes. Companies will have to be ready for data privacy regulation to kind of regulate those kind of behaviors. So, and then the deletion of data, the data location, portability, all these areas are the ones which is going to fundamentally change the way and the policies of organizations, and they need to start thinking of what kind of technology enablement they'll require. And that is where how we think of the way we enabled GDPR level protection, not just to Europeans and residents of Europe, but also those protections are today available globally. So cloud enables us to holistically look at the shaping of different privacy regulations around the world, from California to Singapore to China and India now, and how does it truly allow us to bring compliance in a way that is not just a matter of being on the right side of the law, but also how does that help companies look compliance as a journey to really enable them to bring more trust in technology, bring more trust in their services across the customer front, and then I think look at legislation as a way to develop far bigger businesses because they have the trust, and they are also on the compliance side. They are also looking at how technology enables them. So, Arun, that is how I feel that we will see the changes in the way business accountability and responsibility will shape up, and that's going to overall improve the governance of data and AI.
Thanks, Keshav. Just Shri Krishna, while we were waiting for the technical issue to be resolved, we sort of presumed to start off. But I will now obviously take this opportunity to direct some of that in your direction. I think Keshav mentioned a very important balancing act here. The balancing act between permitting innovation, the balancing act between permitting cross-border flows, the balancing act between bringing the best-in-class global technology into India, permitting predictability, reasonability, allowing businesses to grow, while at the same time protecting various important interests, some of which have become more and more apparent as iterations of the bill sort of go through the process and the consultative process. There's the jurisprudentially, we've always looked at this concept of the least intrusive way of achieving a certain result. There is the threefold test that was laid down in Putaswamy. There are the principles you alluded to in your erudite opening address around proportionality, status, storage limitation, etc. But I want to ask a slightly different question. In times of stress, as the COVID pandemic has proved itself to be, we've seen, of course, that some of these balances tend to tilt in opposite directions. You gave examples of terrorism, for instance, and terrorist funding and so on. Is there still a place for balance to be found? Is that balance found in statute? Or is that balance eventually found in, on the threshold of a constitutional challenge, which I'm sure we will see several of in the months to come? As someone who has balanced difficult problems your entire life, how do you think the JPC and Parliament should look at this balance between individual freedoms, collective needs, and of course the needs of growth and innovation in a country that aspires to be the world's innovation hub?
Arun, there is a slight difficulty here when talking of protection, right of privacy. Now look, if right of privacy were declared under Article 19, they would be subject to the limitation in sub-Article 19.2. No difficulty at all. Speech, profession, business, all that is governed properly. Where is it that is found? It is not an enumerated article in 19 or 17, 16, anywhere else. It has been subsumed in Article 21. And what is Article 21? Article 21 is your fundamental right to life and liberty. So, jaan hai to jahan hai. Don't forget that. Therefore, you are talking of individuals' life and liberty. That is where you have said, oh, this arises. Why? Because Article 21 envisages not only a right to life, but a right to dignified life and not merely animal existence. This is the jurisprudential backing for the whole thing. Now look at how this has been done. Now, for example, Article 21 ensures me the right of liberty. So can my liberty be taken away? It cannot. So what has been done? There has to be some statute, like the Criminal Procedure Code, which will establish a process and say, oh, this man is guilty of this, therefore I will deprive him of liberty by putting him in jail. You remember earlier, prior to that famous Kerala case, A.K. Nambudiripad's case, we had this situation of preventive detention. Now, preventive detention is an anathema to anybody because without trying the man, you put him in bars. Why? Because the executive assumes that he is a dangerous chap. What are you doing? You are curtailing his right under Article 21 of liberty without a due process. And therefore, Constitution had to be amended to add that section there. An article has been added about preventive detention. Strict timelines have been prescribed that he will be given a right of representation within such and such a date. If that is not answered, what is the consequence? Even if that is answered, and then what is the consequence? Then there is a question of preventive detention board. If the board has to see it, if the board says no, everything falls down. Look at the elaborate mechanism by which the right of society to be not to be subjected to a terrorist or to a man who is a bad man because of the TADA or whatever the law that is there intact. And the right of the individual to be given his fundamental right, is been balanced by what? By this elaborate mechanism. That is what is necessary. See, and this kind of a dichotomy is there in every stage of life. Now we have people who advocate that nature should be left alone. Don't do anything, don't cut trees, don't take water. People who say that you can't progress unless you harness water, unless you cut down forests and you build dams and roads. Take a simple thing. Prior to the invention of the aeroplane, people went by horse carriage. Even before that, by bullock carts. Even before that, walking. Number of deaths were the least when people walked. Increased when you started going by horse carts. Increased by automobiles. And increased when you start flying planes. Therefore, progress is not blocked. What are you doing? You build a mechanism. You want to fly a plane? Then let's have this DGCA, you will have this kind of regulation, this kind of regulation. You make sure that the plane is serviced so many times, these 200 tests are automatically met. And yet we lose a general, we lose a group captain. This happens. But then you have to ensure that the mechanism is there. Otherwise, you are not balancing it. You are allowing it to run away on this argument that, oh, data sovereignty, oh, data security. These are mantras. If you can run the country by mantras, that is possible. But if you can't run the country by mantras, you must have an elaborate mechanism. That is what is advocated in Puttaswamy judgment. If you examine any of the judgments, constitutional judgments of this country, or even US or even in England, this is how it has been done. Now, for example, take free speech. Then you have situations of defamation, contempt. How laws have balanced each other? Now, somebody may say, I should be free to talk about anything about anybody else. Should he or should he not? Where is, I remember when I was in college, my professor used to say, your right to swing your arm stops when the neighbor's nose comes in. You swing your arm, but make sure that you don't hit the neighbor on the nose. That is the mechanism that you have to have, either by self-regulation or by co-regulation or by even state regulation. But all subject to this mechanism. That is the way of balancing, and that is the way of forward.
Thank you, sir. I'll ask the question of Harish. Harish, we heard at one end of the spectrum for large global conglomerates and people who have experience working across multiple jurisdictions. Obviously, there is a certain kind of burden. There is the experience of having done this under the GDPR, and we all know the chaos that followed when that came into place. How do you see this impacting innovation at the opposite end of the market? Small and medium enterprises, startups, innovative companies setting up business maybe in the next 2-3 years. Do you see this as being prohibitive? How do you see this affecting A, the investment community, and B, the innovator community?
So it's going to be challenging, right? I mean, there's no two ways about it. And I think let me preface it by saying it's challenging for any startup to work in India in the first place, right? So we are a difficult country as far as regulation is concerned. Right? We are not an easy country. While we may say investment into India is easy, operations in India is not easy, right? So we are a heavily regulated country pretty much across the board. So you will have an additional level of regulation that is now coming in. So it is going to be very difficult in terms of jumping various hoops for startups. But again, so there is a difficulty in terms of compliance, and there is opportunity in terms of creating new methodologies of use of data or use of technology. And it was interesting also, and just an aside, it was interesting also how you have worded, how this topic has been worded, its role of data and regulation of technology rather than regulating data management as such. So if you're going to, are you going to use data to regulate innovation, or are you going to regulate the use of data after an innovation has happened, right? I mean, both are there. And if we look at the last 20 years, which is really where we have seen significant amount of technology innovation in this country, then our laws have not really come in the way, partly because there was a wide area of unregulated, you know, open field for you to innovate. And again, I say this with sort of a little bit of caveat, because in a way, India is a country where there is regulation in every sector. So there's very little area where there is no regulation. In fact, we're talking about the PDP, or the data protection bill, only because a new sort of fundamental right has been guaranteed. Otherwise, there were efforts. There are existing regulations under the IT Act and others which try to plug the gap. So any sort of intervention through regulation is going to create, in my view, some compliance requirements for new innovation. Whether you're able to manage that, I think you will be able to manage that. Whether it's going to put an extraordinary burden on small players, the answer is yes. But then again, I think there's an opportunity there also. So can we, for example, think of public utilities that look at managing data on behalf of small players? Can we create a conglomerate of entities that can look at, similar to what we have, say, in the cooperative sector, to look at, something like, creating pools of data or pools of small players and managing that entire data and technology? I think there is opportunity for innovation, but there is certainly difficulty. I would not, shy away from saying it's going to be difficult, because as a regulatory state, I mean, our regulators are not the best in the world, and I say this with a lot of responsibility. And the kind of intrusion and regulation that you're looking at, it's not similar to, say, SEBI or CCI or RBI, the better regulators in this country. It's not even going to be similar to IRDA. I mean, if you look at the all-pervasive nature of data today and all-pervasive use of data and technology today, so the regulator that you're contemplating is more like your revenue officer in each taluk or the consumer forum. I think that is a kind of leap of imagination we need to look at, and that's the extent of regulation that you will see. So do we have the regulatory capacity to regulate yet not stifle innovation, is a question I suppose we will grapple with and come to terms with as we see things unfold.
I think that's a great segue to a couple of specific ways in which the data may impact the evolution of technology. And I think first is really artificial intelligence. Again, Justice Sri Krishna touched upon it in his keynote, and I think it's top of mind, obviously, for you, Keshav. I think the committee historically took GDPR takes an interesting approach to inferences through artificial intelligence and inferences from automated processing, as it seeks to describe it. The committee, in looking at this, examined this from the context of seeing whether this falls within the subset of fair and reasonable processing. The boogeyman globally across multiple jurisdictions has always been, does a requirement of fairness and transparency, does a requirement of showing your inferences, so to speak, amount to a requirement of algorithmic disclosure? Knowing, of course, that all of this is up in the air, and we still need to see the version of the PDP bill that's going to be tabled. Keshav, I ask you this, as at the head of sort of looking at innovation in this space and looking at bringing a lot of state-of-the-art knowledge into the country, the ability to innovate using that knowledge in the country, do you feel that fair and reasonable is a good standard for regulating automated processing? Or do you feel further disclosure, further mandated transparency is of course necessary here? And do you think it will have the effect of stopping somebody from doing something that they would otherwise have done?
Thank you, Arun. That's a very profound question, right? And I'll build on what Harish said about regulations and how they shape the behaviors, and also how they sometimes create friction in the ecosystem. And I think that's something very critical for us to understand. The success of any legislation is a combination of enablement, protection, where state comes in the the middle to kind of make sure that rights are protected, but also can it really bring all the stakeholders together? And I think AI is one area that we are, it's all around us because it is harnessing, because data is the fuel of AI. Without data, AI just remains as algorithms, right? You can't do deep learning or machine learning without the data. But I think Justice Krishna spoke about the integrity of data, right? As to how do you really, and that is a big question mark today, right? Is data usable? Is data trustworthy? Does data have the right classifications? And I think when we think of the use cases of AI, I think there is a journey for all of us, right? I think AI today resides in our phones, in any app we use, whether it's map or we order something or we browse an e-commerce website or send mails. It is constantly working on our data. But AI has also evolved, as I think is evolving in terms of that it also has potential harmful uses. Not all AI uses can be said to be good, because AI is supposed to absolutely solve for the societal issues, hunger, poverty, crisis and humanitarian or even economic issues. How does it help startups to build a business? They're all cloud native corporations, but as a company, we have been very thoughtful about AI. We believe a technology should not be unleashed without any boundaries, because when we think of the way technology can enablement, it can also cause harm. And that's where we developed the responsible AI principles, that while AI leverages, but if the back end of the data and the algorithms are not written correctly, they can cause biases. And we've seen many examples of even justice system using in US, and there was a bias against certain racial profiling. We've seen how when you put up search on a search engine, how the AI kind of has a bias in the way the images show up, right? So in the book, in fact, our president wrote a book called Tools and Weapons, because he's saying that while technology is a tool, is a service that can enable companies, governments, and citizens to really improve their lives and do better. And it's also democratic; everybody can access it. But it also can be a weapon if not regulated properly. And I think Justice Krishna spoke about surveillance, and we developed facial recognition principles to say that we believe there should be clear accountability to the developer of AI algorithms and the accountability of data providers, and also how that AI gets trained and then applied to users. There should be fairness, that AI should not lead to biases. And look at the diversity of our country in itself, but also look at the diversity of the world. And these biases exist in a human mind. So imagine if you're talking about a artificial intelligence, which is just augmenting human capability. We are inherently born with biases, right? I think that we must understand. You need to really protect. And then fairness aspect, and also accountability. We believe that one of the principles is saying that if and there's no law right now, and that is a greenfield area. And I think that's where we need to be really thoughtful as to how do you really evolve these principles, starting with corporate practices, but then it becomes more of a regulation in the standards, that AI and technology also need to be accountable if they causes harm, or if they causes wrong, unintended consequences can happen. So we believe this is an area where I think we all need to be thoughtful. Then we're looking at quantum coming up, right? And that could have a massive impact. It's more powerful, very powerful, and we can't imagine how powerful it is than AI currently. But we need to make that journey of responsibility and accountability of technology companies and tech users, as well as how users adopt technology.
I'll take that question to Justice Sri Krishna. I know the committee thought long and hard about this. There were several submissions made by you, by the leading innovators in the space. There was a hard balance that you had to do between hard coding some of this into black letter law, potentially requiring sort of pushing it down into delegated legislation, potentially requiring responsible AI principles to be put in place in a data protection regulation. And yet, the approach you took was perhaps the most balanced one, of saying have the fundamental concepts of fairness and transparency, have the fundamental principles of data protection continue to apply, whether it is processed manually, processed by AI, or through automated means. Would this, just given how far technology has moved since that report was first written, given how the world is increasingly focused on AI today. Is that how you would continue to think about it today? Do you think that solution still works? And two, how do you see this being operationalized by the Data Protection Authority?
Arun, don't forget that technology is not an end in itself. People somehow always mistake the end to the result. The technology is a means to achieving an end. What is the end? I suppose greater happiness in society, greater satisfaction, greater human potential development. That is your end, right? Technology is just a tool. Now look at what happens in ordinary life. Forget all this highfalutin technology. You have a sharp knife in your hand. My wife uses it for cutting vegetables. And somebody in the hand might take it and stab people. Take a gun. Gun is useful if you are going to fight a terrorist, if you are going to fight across the border. But if you start shooting people in your own house, you're killing people. Gun is bad. Therefore, can I say that it is the technology that is bad? No, technology is equal. Whether it is in the hands of a saint or a crooked man, the sharp knife will do the same thing. So it is the wielder of the weapon who must be responsible. So the responsibility, accountability must be of the person who is wielding technology. Now, I always look at it this way, and I've always said it on open platforms also, that I look at it like three sides of a triangle. Now, what are the three sides of the triangle? The citizen is at the top because everything exists for the citizen. Take away the citizen, there is no state, there is no nothing. Citizen is there, citizens come together, they make the state. So citizen at the top vertex. One vertex is the state because the state has to work hand in hand with him and give him all that is necessary. The third vertex is trade and technology and commerce because they exist to generate happiness, generate ease of transaction for the benefit of the citizen, but being regulated by the state. So do you have a triangle of forces? And the ability of the country to go forward depends on what is the resultant force of these three triangles. Now, you are all technical gentlemen, you understand what the triangle of forces and where the resultant will be. Now, it is the resultant that really qualifies to say, hey, this country is good, this country is not good. Now, you were asking me whether this balance has been noticed. This balance has been noticed, and this balance has been throughout. Now, nuclear energy is something that is absolutely necessary today because we have come up to this conclusion that fossil fuel is no good, coal is all being depleted day by day, and coal is also creating all kinds of environmental problems. Therefore, more and more technology of nuclear reactors and nuclear electric power stations. Now, this itself has a problem. Now, if a thermal power station breaks down, the damage is, let us say, X. But if a nuclear power station breaks down, or if there is lack of integrity, then the harm that will result is 1,000 or million times X. Therefore, the balancing will require that the regulation of a nuclear power station must be 100 times or 1,000 times more than what you do in a hydroelectric station. But this is a simple logical process. Whether you regulate bicycles or motor bicycles or cars or race cars, it's the same thing. The balance has to be there, and the balance is possible. It is not that it is not possible. How is it to be effected in actual practice is this. You look at the nature of the right, you look at the harm that will befall to the citizen if the right is not allowed to be expressed easily, if the right is subjected to all kinds of regulations, which are really not required. That is where the doctrine of proportionality is there. Now, I always give this example and say, you want to cut an apple, use a fruit-paring knife. Don't use a battle axe. If you use a battle axe, that is unconstitutional. If you want to kill a fly, use a swatter. Don't put an atom bomb. Atom bomb also will do the same job. But along with the fly, 1 million people will also die. Therefore, proportionality is the thing that has been harped upon in the Puttathami judgment and all the previous judgments going all the way to A.K. Gopalan's case. So that is how balance has to be achieved. True, and in society there is always dissension. One section will say, for example, take a simple thing like vaccination. Somebody will say, I don't want to take vaccination because it is a right. Somebody else will say, hey, your fundamental right is to catch COVID and give it to somebody else. That is absurd. Therefore, there has to be a balance. Therefore, I'll make you go and go through this. If you don't, I'm going to freeze your, now governments have started doing, I'm going to freeze your salary. I'm going to put you in confinement. That is possible. Why is it possible? In the interest of the larger interest of society. If everybody in the society is going to be affected by one man's ill-thought and ill-articulated opposition, it is time to tell him to shut up. That is where the right of speech also has to be controlled, right of vote has to be controlled, and right of privacy right also has to be controlled. But beyond that, it's a situation of go and throw an atom bomb to kill a fly. Use a swatter, kill it, that's fine.
Thank you, Justice Sri Krishna. Harish, a slightly different variant of this question to you. We see so many businesses, especially startup businesses and younger businesses, relying on infrastructure which is developed elsewhere, whether that's AI as a service, using compute capacity remotely, creating perhaps innovation on the back of other forms of innovation which have been created elsewhere. Effectively putting more and more cards on top of an underlying structure. Now, we're aware, of course, that concepts like sandboxes have been put in place to maybe enable this innovation at a smaller scale. But do you see this need, for this fine proportional instrument to regulate what is a potentially very powerful and disruptive technology, forming a legal impediment to innovation and development? Do you see it forming a source of uncertainty to investment in the space? Can I, as a domestic or foreign investor, putting money on an AI enterprise, knowing there is a strong potential that there is a registration requirement around the corner, there is the possibility of some form of disclosure, whether that is inferences or depending on how the DPA comes down, the portability right being read more broadly, where there are these potential existential risks. How does somebody investing in this space, whether that's an entrepreneur investing his time or an investor investing his money, how does he think?
Right. I think it's an interesting question, and it's actually quite fascinating, right? And to look at how as a country we have regulated various sectors, particularly post sort of 91 and 2000s. And I want to take two examples. Since you're looking at it from an investor and innovator's perspective, right? If you see the last 20, 25 years, investment and innovation has not shied away from, potential, what should I say, gray area, legally gray area sectors, right? Where they have stopped is, where actual prohibition, complete total prohibition, does not mean money flowing in there. For example, take one of the sort of areas that was always prohibited was defense and agriculture and things like that, right? No private investment in those sectors. It was very clear because the message was very clear. But let's take our the example of e-commerce and the entire environment around that, in terms of whether it's wholesale, retail, single brand, multi-brand, the various complications. And also take telecom in the early stages. All these were potential gray areas because there were many, issues of regulation where it was not clear whether what you were doing was 100% on the right side of regulation, or you were transgressing at various stages, and whether the government could come down at any stage. But still, innovation happened, still money flew in, because the demand of the market and the size of the market was too much for people to ignore. And people were happy to take risks as long as they were compliant, as long as, using, I suppose you could say that I'm copying out by saying they followed a fine, reasonable balance. But that's the nature of how innovation also works, right? So I'm not so worried that the absence of clarity on regulation is going to stifle innovation. I'm not so worried about that. Okay. I think what we should be concerned about is if the power to prohibit is delegated to, if the power to prohibit is used very extensively by regulatory authorities, then it will stifle innovation. So, and that has not happened, except in a few sectors. It has not happened in India so far, and investment has flown in. And investment is not shy of sort of taking risks when the regulation doesn't actually prohibit, but there's a gray area. So I am not so worried about existence of gray areas. I'm worried about whether the statute will, if it gives too much discretion to certain officers or certain authorities, and whether that discretion, if it's not very clear. And again, if we take a look at see how the RBI used to regulate past regulations under FEMA 20 years ago and how it does now. Now there's a lot more clarity in terms of. I know Justice Sri Krishna is saying, he's smiling. That we can say there's a lot more clarity because there is certainty at least for 1 year because of the master circulars. Earlier, I remember when I started my career, and following the FEMA circulars was two lawyers' job, right? I mean, you didn't know what came out when. So we can't be in that kind of scenario. So if you're in that kind of scenario, then I think it will certainly hinder some sort of business continuity. So all regulation, right, just like all law, you need certainty. And if there's too much discretion in regulatory hands to keep changing and chopping things, then that's a problem. That is what we should aim for. I think reasonable and fine balance, fine, but it shouldn't be arbitrariness. And I think that's the issue. Arbitrariness will certainly stifle innovation and stop private money flowing in or investment flowing.
Harish, I would like to intervene here. Harish, you talked about RBI's discretion. Let me give you an example. I was heading the Financial Sector Regulatory Reforms Committee. Now, at that time, one of the questions I raised was, in Africa, they were using that M-Pesa, mobile transfer. So why can't we do it? And I was given a long lecture by the RBI people, including the Deputy Governor and the Governor himself, that it is very dangerous for the economy of the country. It is going to destroy the economy of the country. 4 years down the line or 5 years, I don't know. We have all become now, we transfer money on the phone. So what has happened to the economy? How did this economy suddenly become regulated? Now, 2 years ago or 3 years ago, somebody came to me and asked me a question about, he was a man who was running a company doing cryptocurrency. So he said, how is it regulated? Now I said, I don't know, there is no regulation. It's not a coin, it is not money, it is not tender, legal tender, it is not security, it is not anything that is defined by the acts. I showed him various acts. So I said, why don't you go and ask the RBI? He went to the RBI and the RBI told him, some gentleman there, obviously at the very high level, that today we are not saying it is bad. We don't have any law which covers you, but you do what you want. Later on, we'll see what can be done. A regulator can't do that. Damn it, regulator is supposed to hold your hand and tell you, hey, do this, don't do this. Or sandbox it, saying that, all right, up to this threshold, I will allow you to do it. If something bad comes out of it, I'll clamp down regulation. That attitude is necessary. Otherwise, innovation is never possible in this country. Now, drones. Now, nobody knows what is the situation of drones. Drones can be used safely in this country or unsafely in this country. Does the DGCA control it or the drone controller controls it? What is the regulations? I don't know. I have not seen the regulation. I don't know. Arun, have you seen it? I have not seen it. Although there is a lot of this is the problem, you see. Somebody should sit down and say, hey, these are the... And it's not very difficult. It's not something that's being done first time in the whole world. Somebody has already done it across the jurisdiction. Look at what he has done, what problems he has faced. And actually, I'm sure you can interpolate it here and say, all right, here we'll do this. We'll add these super conditions. That is how innovation has to be encouraged. That is why this Singapore's regulator is excellent. They have, of course, sandboxing has started in India now. I think in the last 1 or 2 years, we have come up with sandboxing. Otherwise, sandboxing was the first thing that the regulators abroad used to do it. That saying that, all right, we don't see actually anything harmful coming out of it. Up to a certain threshold, we'll allow you to do it. We'll examine what happens and then decide what regulation is. That encourages investment, that encourages innovation, that encourages going forward, and not simply saying somebody sitting in Delhi saying this is good, this is not bad. Why I'm saying so, that's all. That ipse dixie comes down, that's all.
I want to take the opportunity to segue to what is a potentially very interesting development. Now, the jurisprudence around the Personal Data Protection Bill was based in the law surrounding the right to privacy and the proportionality or restraint, if any, on it. As Justice Sri Krishna again pointed out in his keynote, we see now that a almost completely different, expressly at one point the committee had expressly stated that this was fundamentally incompatible concept of non-personal data, which is sought to be brought under this overall umbrella. So I want to raise a question that is more definitional, and it ties in actually to the points both that Harish and you, Justice Sri Krishna, made. Firstly, what is this non-personal data? Is all data that is not personal non-personal? And if, as a little bird tells me, the requirement is going to be that a non-personal data breach has to be notified to the Data Protection Authority. If rules are going to be put on around how non-personal data is going to be collected, stored, and processed, whether these are taking on the same cast as the relevant committee has proposed under Chris Gopalakrishnan, or whether there's going to be a variant of that which is going to be put in by way of delegated legislation under the Personal Data Protection Bill. Is it even possible to regulate something which, at least to my mind, is very difficult to define? Number two, if it is going to be regulated, can it be regulated under a framework that has been built on a foundation of constitutional protection of fundamental rights? I'll start with Justice Sri Krishna, because again, he's had the unfortunate joy of seeing his creation sort of warped, much like Dr. Frankenstein. So I'll start with Justice Sri Krishna and then move to the rest of the panel.
Very well. Now that you talked of Dr. Frankenstein, let me tell you, Vinayakam Prakurbano Rachayamasa Vanaram is a saying in Sanskrit, which means somebody wanted to make a murti of Ganpati, and what came out turned out to be a monkey and nothing. This will not happen if you don't apply fundamental principles. You see, the point is, what are we trying to achieve? We are trying to achieve the benefit to be available to every constituent in the society. Now, all that you need to regulate is that the evil effect is regulated. Otherwise, where do you have to regulate? RBI's great regulation comes for what? The inflation should not go up. The monetary value should not drop down to zero. These are the two concerns. Otherwise, why should they bother about how much money I got? People traded long ago, even before the Phoenicians invented money. I would give you 2 sheep and buy some grains from you. It was going on. No, the world was going on. It was nothing very great about it. But in money became a complicated issue, and therefore they had to do all this regulation. Now, if this regulation is to be taken to a logical extent, then regulation should be, take for example, any regulation. Now, how many of you are from Bangalore? I think Dakshi, Harish is from Bangalore. Arun, you are also in Bangalore, no?
Yes.
Now, take the state of traffic in Bangalore. I mean, less and the better. Any civilized country cannot have that kind of, I'm sorry, whoever the traffic authority in Bangalore will feel that I'm saying this, but it is a fact. I refuse to drive in Bangalore. Now, regulation is necessary because it is not possible otherwise to carry on without accident. Therefore, we get so many traffic signals, so many ways, so many, what do you call them, flyovers. It is now that is done we do to carry on with it. Sorry, I think something went wrong. Okay.
Yeah, I think
so therefore,
video is not this. It continues.
Yeah, I thought there was some interruption. I see. The point, regulation and innovation go hand in hand. If the regulator allows a certain amount of elbow room for the innovator, keeping all in the while to check that what is the evil that is going to come out of this elbow, of this activity, and that is when you should regulate. If you adopt this approach, I think the balance between innovation and regulation would have been achieved brilliantly. Now, how to achieve it in a particular jurisdiction is a matter of detail. Somebody has to sit down and apply his mind to it and come. Now, Arun raised an interesting question and said, what started off with the personal data protection bill on the constitutional pedestal? How is it going to be compatible with the data protection of non-personal? Non-personal in negative definition is always a dangerous. Now, if you say, I am a human being, I am a man. So, non-man could mean a woman, a beast, a stone, a river, a mountain, anything. The problem here will be every company will have certain amount of personal data, non-personal data. Now, what is the example of people then immediately turned to me and told me, oh, non-personal data will become the IPR. I said, there will be IPR is a different kettle of fish. IPR is something that you have ensured for trademark, for copyright, for patent rights. But I can have data which is non-personal, which does not fall within these categories. Now, for example, I gave an example the other day. Now, if I am going to have a policy document or a board resolution saying how am I going to source my raw material for the next 5 years, how am I going to raise finances, whether I am going to bring an IPO or not, if not, why, if yes, why. Now, these are matters which are confidential to the company, and it really affects the growth of the company. But this is non-personal data. Now, does it mean that this non-personal data is also to be recognized and regulated by the DPO, or is it going to be freely accessed by the government on one reason or the other? And next question is, does it have a constitutional protection at all? If it is started to be taken away. That is why I said, please, for heaven's sake, keep them separate, deal with what is constitutionally protected by a separate act, and that is why originally they started with the right attitude. That Chris Gopalakrishnan committee, I think it didn't even have lawyers, it just dealt with the technical aspects of it. Finally, it made principles, and one assumed that there will be a law which should incorporate the recommendations of the Gopalakrishnan committee. But unfortunately, somewhere along the line, somebody has jumped again, and then quarrels these two immiscible things, if you ask me. Because what is true of personal rights is not true of non-personal rights. What is cheese here is chalk there. Now, if you say cheese is white, chalk is white, let them put together. God help us, that's all. So it is not possible to carry on with this. And you will notice that there are situations where it will become difficult to separate what is personal data from non-personal data. And I don't know how the legislation is going to impact, to what extent, because the legislative mandate, the legislative protection given to non-personal data is of a different character, to personal data is of a different character, and how this is going to play out will have to see after the law is enacted, and whatever the law is, will an exam sit and examine it, and maybe you can have another long session on this.
Thank you, Mr. Krishna. I'm conscious that we've run into our time limit. As all good conversations, I'm afraid this one may have to end a little abruptly because we're running into the time of the next panel. I want to hand it back over to Mr. Vasani and the team from Bombay Chamber to close this panel out.
Thank you. Thanks a lot for a wonderful panel discussion. And as Arun said at the end, that it has come to an abrupt end because We were enjoying this conversation. I wish we had more time. But Justice Sri Krishna, we would like to call you again. Bombay Chamber loves to have you. You've done that in the past, and with the current law coming in, perhaps we could have another discussion soon. So my heartfelt thanks to Justice Sri Krishna for taking our time today and spending almost more than 2 hours with us, and also to all the other panel members, Keshav, Harish, and Arun for a wonderful discussion. So thanks a lot from the Bombay Chamber side to all of you all for your time, and I'm sure the participants really enjoyed this conversation. Thank you.
Hi, Shanaz, am I audible to you?
Yes.
I think there is a slight lag in the audio, but yeah, I can.
Okay. Sure. Mr. Ganesh Kumar, can you hear us?
Me? You're able to hear
Mr.
me?
Kumar? Yes, yes.
Yeah, please go ahead.
Sure.
Yes, Shanaz.
So I think I think then we'll start the session here. So hello everyone. Welcome to this session. I think the last few years we have witnessed a surge of activity in the crypto markets. Now the global crypto market seems to have exploded. I mean, with just around USD 16 billion a couple of 5 years back, to recent reports showing that it has sort of reached USD 3 trillion. Now we have seen prices of various cryptocurrencies skyrocketing and then crashing. We have seen investor interest in this sector. We have seen price volatility. I think maybe we can switch off the mics where we are not using, perhaps. So yeah, so as I was saying, there's been a lot of sudden investor interest in this particular sector. There has been a lot of price volatility that we are sort of seeing in this particular asset class. We are witnessing how these kind of asset classes are being used for cross-border transactions, concerns being raised around illicit activities of such crypto assets. So I think these are issues which are sort of troubling policymakers. Now, while many countries started off to sort of ban with the sort of a decision to ban crypto assets, but recently we are seeing more countries moving towards regulating crypto assets. Now, of course, India is not an exception to this policy dilemma that most countries are facing. India started off with a sort of an approach to ban crypto assets, but slowly is moving towards regulating this sector. Now, proponents argue about the opportunities that crypto assets present and the underlying blockchain technology presents for the financial sector, whereas I think critics remain skeptic about its possible misuse. As India looks forward to a bill to regulate crypto markets, I think it is important for us to deliberate on the regulatory approach. Questions arise as to how do we regulate something when there is no underlying asset? What should the contours of these law look like? Now, to understand these issues with me, I have with me a panel of experts here, Mr. Pramod Rao, General Counsel of ICICI, and we have Mr. Ganesh Kumar, former Executive Director at RBI. We will also be taking up questions, so please do type in your questions for the panelists, and we will definitely be taking up at the end of this session. In terms of format, I have issues that I would want to kind of start pose to a particular panelist, and the other speaker is more than welcome to sort of comment on that. So I'll quickly begin with the issues that we have today. The first issue that I think I would like to kind of draw upon everyone's attention is on the regulatory approach itself. As India is deliberating on a bill to regulate crypto markets or crypto assets, I think it's important to understand how should that regulatory approach look like. Mr. Kumar, I'll go to you here. Now, I think we are seeing that policymakers are in a sort of a catch-22 situation. When you regulate crypto assets, you sort of legitimize it. If you don't regulate crypto assets, you sort of create this, sort of a market, concerns around the growth of a reckless market. Now, globally, what we are still seeing is that policymakers are still trying to figure out what the contours of the law for crypto assets should look like. And most of the regulatory interventions has been through advisories, warnings, or even perhaps amendments to existing laws. Now, I just wanted to get your thoughts insofar as India is concerned. Can crypto assets be regulated under existing laws, or do we necessarily need to think of a separate legal framework for cryptos in India?
Yeah, thanks, Shanaz. You've set the right tone for today's discussion. Let me try to bring some amount of clarity, the perspectives which the regulator will have. I'll talk about the regulator's role. I'm not with the regulator, so the usual statutory warning or the notice applies, stating that this is not the view of the regulator. But nevertheless, I will try to say what the regulator would like to look. And when I talk of a regulator, it is a generic regulator. It could be the assets-based regulator, which is the SEBI, or it could be the Reserve Bank, which has, like Justice Sri Krishna was telling the previous session about whether it is inflation monetary targeting or inflation targeting, or whether it is relating to the payment and settlement systems under which the crypto is supposed to be actually checked in. So before this, let me backstep a little bit, and then I'll come to the issues. The entire reason why the crypto issues relating to the lack of clarity came in is because of the fact that the technology overtook the business overtook the laws, and therefore we are in this situation. Back home, since Pramod is also from the banking sector, and all of us are aware of and use cards to a large extent, let me just try to relate it to, let's say, 3 decades ago. The first credit card in the country was actually introduced in the early 80s. At that point of time, there was no regulation on credit cards. There was no framework relating to credit cards. And many of us will be surprised to know that the first credit card was actually introduced by a public sector bank. Of course, there were no private sector banks the way it was there today. There were only a handful of them. The card industry had almost a 13-year period of free run. They did the way they want. The rules were what the card industry framed. The banks decided what they want. The merchants had their own say. Things like merchant discount rate, etc., which everybody is now aware of, were things which were only privy to a small club. Nobody regulated it. Why did nobody regulate? Because there was no systemic impact of the card industry. There were a small handful of people who were using it. It was more from a perspective of convenience. It did not pose a threat to the economy. It did not pose a threat to the banking sector. It did not pose a threat to the customer, to the citizen who was actually using it. And therefore, there was no regulation. Fast forward to 1996, which was almost 16 years since the card industry started. The growth of cards was very high. All of us know that during the mid-90s, how people used to sell cards, and we used to get cards even without applying for a card. And then the general thing was, you have already got a card, so pay me a credit card fee, or pay me something like this was happening. And interest rates on that was usurious. In other words, the cards got what typically a regulator will call it as a systemic risk, meaning that it was impacting the system, it was impacting the common citizen of the country, which is when the regulator came in with regulatory guidelines. And therefore, the credit cards industries came into guidelines, into the regulation only in 1995, although the sector was in operation for a long period of time. I very much wish that the same thing would have happened in the cryptos. The cryptos had an entry into India just a few years ago. You can count the number of years. But then, unfortunately, when the cryptos entered into the country, it was a big bang approach. A large number of sectors actually joined them. And thanks to the usage of technology with especially the younger generation, everybody joined the bandwagon of crypto. People were thinking that here was an arena to make huge amount of profit. Now, whether this profit was based on an underlying, which is rightly what you said, whether it was based on an asset or not, it was not very clear. So somebody used to think of crypto as an asset. So you trade on it, you may get a profit, you may endure a loss. Somebody else, going by what everybody was talking out, and the media was, I'm talking including the electronic and the digital media, was giving a hyperbole about the huge profits that people were making, and Bitcoin, this tremendous growth that it was making. People were thinking that Bitcoin can be something which people can trade and everybody makes profit. Now, there is no free lunch in a real world, and that if somebody makes profit, somebody else has to make loss. So the regulator had to come in. And who is the regulator? Now, whether Bitcoin, the way it was, I'm using the word Bitcoin only because that was the first one which came into the country. Others have followed now. Because the word which was used there, is it a crypto asset or is it equivalent to a currency? Because world over, some economies started saying that you could use it as a medium of exchange, which was not the position in India. So in the absence of a regulatory framework and to give customer protection, and when I say customer, these are not customers of any institution, these are ordinary citizens. To give them protection is what something had to be brought in quickly. Now, that is where the stage was set in for the type of regulation that we are seeing now. I'm not saying for a moment that it is fully comprehensive. It is not taken care of. The cryptocurrency bill in this current form is also, I fear, will undergo multiple revisions, and perhaps it will meet the requirements in due course of time. But then people are actually using it. Like Justice Sri Krishna said in the previous the panel discussion, there's nothing wrong in people actually using the crypto, using it as an asset and trying to trade with it. As long as they understand that if something goes wrong, they will be held holding the baby. If you go back again to the Harshad Mehta scam, when the scam broke out and people lost money, everybody said the government should have done something, the regulator should have done something. Precious little was actually known to the fact that people knew with their eyes open that they were entering into an area which was fairly risky. We don't want an encore of that, and that is why there was something which the Reserve Bank tried to do. I'm not in hindsight trying to rationalize that, but they tried to say at least banks should not be exposed to that. And therefore, if banks are exposed, the depositors of banks will be impacted, and you've seen the spate of bank failures or the potential failures that have happened. To prevent that from happening, because in a technology world, when money multiplier happens at a very high speed, crypto has the capability to even disrupt good managed healthy banks. That was what it was done. But the last word on crypto, who should regulate what it is, depends on how and who classifies crypto. My view would be, and that is what you also hinted at, Shanaz, is that there needs to be an underlying asset. So if crypto has an underlying asset and it is treated as an asset, logically it should be actually regulated by an entity which actually regulates assets. That is why perhaps of late we are hearing that SEBI should be the regulator, because SEBI does regulate assets. But that does not mean that RBI will not have a role to play, because crypto, by the way it is happening, doesn't have geographical boundaries. And when there are no geographical boundaries, there are impacts on foreign exchange. And if it has an impact on foreign exchange, the FEMA gets impacted. And if FEMA is impacted, the RBI has a role to play. Similarly, when you deal in an asset, the settlement of the asset has to take place in the form of money, whatever money you call it, and that comes under the payment and settlements regime, under the act which is empowering the RBI to do it. So in my view, what is going to happen is we are going to see a different type of regulation happening now. There will be a prime regulator, which could be SEBI. I'm assuming for the time being that it will be classified as an asset and SEBI will be doing it. But then there is going to be a lot which has to be interrelated with RBI as a regulator, government, because it's going to be done through an e-commerce marketplace. So the Ministry of Commerce will have to have a play. So it's going to be, the future is going to be not one specific regulator, but multi-regulatory or a sectoral regulator approach. So this is what is going to happen. Until such time clarity on this comes, it's going to be free for all. it's going to be the way people are doing it. So the only hope that I have is that people who are doing it are fully educated, they are aware of what they are doing it, and they are doing it on their own, not later on when they lose the money to come and say, look, if I had known, I would not have done it, so government has to help me out, or a regulator has to help me out. So this is what it is. I've tried to give a balanced view. I'll stop with this before becoming a bore, because there are a lot of pundits in the crypto space. Every day there is a new PhD based article coming out in the media, so people are getting confused. I don't want to confound the confusion, so I'll stop with this and leave it to the other experts to actually add, and we'll be happy to take questions at the end of the session. Thank you.
Sure, thanks a lot. I think this is very helpful to kind of set the context to understand the various aspects of regulations that we will have to think about more from a market conduct aspect, as well as perhaps from a systemic risk and financial stability aspect. So I'll perhaps get Anu here in terms of, Anu, we were discussing in terms of how what should be the regulatory approach for regulating crypto assets in India, whether existing laws are enough or do we need to think of a bespoke regulatory framework. So I thought I'll get your sort of thoughts on this also.
Thank you, Shenas, and very good evening to Mr. Kumar and Mr. Rao. Possibly, barring data protection, no other topic has evoked the kind of interest this one has. And I'm sure a lot has been said on this question, so I'll keep it brief on this, Shenas. I think the issue is twofold. Firstly, as rightly Mr. Kumar said, one was the Harshan, second in recent memory, I remember the NSCL. And I'm not sure if justice has been delivered even after 2013. We're completing 10 years of that. So, it's something, what is the law doing? KYC, PML, and settlement. But settlement again depends on whether your stable coin is something underlying or not. So possibly slotting it, under an existing framework, again, if it could be, had to be, should have been slotted. Because for the last 4 or 5 years, the whole debate whether digital assets are currency or commodity or security has been going on, right? So either it is reluctance of regulators or it is inability to be able to classify given the nature. So possibly, definitely needs some kind of a new framework, whether it gets slotted within an existing regulator or a new regulator, like for example, how it's proposed with the PDP as a DPA is time will tell us. But I think whoever is looking at regulating it, whichever form or shape it takes, I think the key issues which ought to be covered is firstly, as Mr. Kumar and Mr. Rao also had alluded to this, is customer protection. That I know what I'm doing and I have protection in terms of as an investor. Of course, the AML KYC is a big piece. And lastly, I think the whole fraud risk, whenever there is financial services involved, there are good actors and bad actors. So if something goes wrong, and the whole struggle at some level with any SRO framework world over, not just in India, is it's a bit of a traffic light approach. Without a cop standing at the traffic light, would you jump or not jump the traffic light? Is an SRO equivalent? So let me pause there and over to you, Shehnaz.
Sure. Thanks a lot, Anu. I think it's helpful to kind of also start this discussion on understanding what the contours of the law should look like. Pramod, I'll move to you. Now, we have seen regulators have remained cautious of crypto assets, but they are advocating for blockchain technologies and innovation around blockchain. So I just wanted to kind of understand, will blockchain innovation be possible itself without an enabling framework for crypto assets?
Sure. Thanks, Shehnaz. And I think I'll just build on what I heard Mr. Ganesh also talk about. So very quickly, I see crypto in maybe 3 or 4 lenses that he also described. Currency or payment instrument. I don't see that catching vogue. I don't think there are merchants selling goods or services for crypto. So, while that is touted, I don't think that's a utility because people continue to look at it, I think, far more as an asset, which is appreciating in value. Anything which rises can also fall, I think, is the caution that they should bear in mind. Those assets can be both with the underlying and without the underlying. With the underlying, I would believe, come under the category of stable coins. Without an underlying means that they really have nothing backing them, and that's where I guess those who buy or invest in those should be most careful about. I think the third situation or the fourth situation would be where people use or raise money against the issuance of tokens or do what is called initial coin offerings and so on. And finally, as you said, that could it be a reward for a blockchain, right? And therefore, can blockchain survive without a crypto legislation? I think if I had to just quickly go to that last issue, I would say that there are private blockchains possible, there are permission blockchains possible. We don't have to look to public at large having to validate the blockchain as such for us to utilize them. And again, we should remember and keep in mind that we need blockchain where currently we don't have registries or databases which can keep track of certain transactions or assets. We do have them in the securities market. I would say it will be pretty hard to say blockchain can replace what, let's say, the NSDL or CDSL have managed to do, right? Capture a whole host of data about our securities and the transactions that occur in them. So it is, again, got to be applied for where we believe that there is no actual registry or repository, and can blockchain do that? To that extent, as I said, we ourselves are part of a Indian blockchain, Indian Bank's blockchain consortium, and the intent is to apply it to several different things. And the key anchor there for us is that it is permission. It's not going to be available to public at large to sort of mine that chain. It will be something which the members themselves will sort of do, right? So therefore, this thing of saying that crypto rewards those people who perpetuate the blockchain, I think we need to take out of the argument, because as I said, it can be private, it can be permission. It need not therefore be a motivation for people to come in and use, would be the view I would take. Let me pause there, though, there are several things which I think are interesting. I heard Anu say, Mr. Ganesh say. So I know we have a lot of agenda to cover. So let me pause there and hand back to you, Shana.
Sure. Thanks a lot, Pramod. And I'm happy that you sort of brought up this issue about how different kinds of crypto assets or tokens sort of exist. And this brings me to the question. And I mean, I think we all are in an agreement that, of course, we are not looking at crypto assets as a sort of a legal tender. But of lately, we are seeing that people have sort of advocated for it to be viewed as a sort of an asset class. But what does that mean from a legal perspective? What will be the legal implications if crypto asset is viewed as an asset or as a commodity? And is this even a correct classification? Because I feel that, as you correctly pointed out, we are also witnessing security tokens. We are witnessing the rise of stable coins, where these are perhaps sort of imitating features of existing financial instruments, like perhaps securities. So that is what my next question, perhaps, Anu, to you is, how should we look at this classification of crypto assets? Can we kind of categorize everything into one asset class, or do we have to think about a classification based on their functional use?
Great questions, Shenaz, and I feel it is going to be, based on my experience in this field, it is going to be very difficult, if not impossible, to pigeonhole the entire discussion within one bucket. And possibly, which is also a bit of a worry for the lawmakers. If you look at a traditional exchange, like let's look at SEBI. What does SEBI do? It guarantees settlement, right? Both on the securities market side as well as commodities market side. When I buy and sell commodities, warehouses should have the goods I'm buying and selling, right? And they are guaranteeing, so to speak, the settlement underlier. Same on the securities, BSE, NSE, right? But there you know what the four corners of the product are, right? Now, as Mr. Rao rightly said, tokens. There are so many questions we are getting now on tokens from cross-border players. Honestly speaking, it is nothing short of gaming to me. If you actually look at it, right? I mean, what is it about token? Unless it's a wallet, it's a game, so to speak. Right? It can be a fantasy game. So the struggle I see, and this possibly is an issue with any area of this nature, you don't know going forward how it might branch out, in what all forms. I mean, NFT. Last year, this time, if you had asked the question about NFT, and who knew what NFT is, and it's changing the art world supposedly. But now, how do you really categorize it? Is this a digital art, so to speak, which means it ought to be covered within the so-called Telegraph Act equivalent of the internet world, if you get the connection here, right? So it's going to be very difficult, which is why possibly what may happen is an approach that you see with any such new age emerging technology. That the law can only set out the guiding principles, like how it happened, say, with competition law, like how it should happen with PDP, and the rule making, the day-to-day spotting new challenges, new use cases, has to be then dealt by the executive, because otherwise, I mean, it can, I mean, leave the whole currency debate aside. That's a CBDC. That's probably an easier fix with cryptocurrencies. But whether a commodity or a security can be either.
Sure, sure. Thanks a lot, Anu. Mr. Kumar, I'd like to get your thoughts here because I think it also, considering the way the Indian financial regulatory architecture works, is that we sort of determine the nature of the instrument and then we have a regulator looking at it. Obviously, in the case of cryptos, the problem mostly arises because there is no such underlying asset in most cases. So, and perhaps that is why we are looking at people saying that, okay, there is no asset class, let's perhaps regulate the service providers. And since it's a market conduct type of regulation that we are looking at, perhaps SEBI is the first name that sort of comes to our mind. But in terms of your thoughts on how perhaps we should look at the classification, and then despite the fact that even if SEBI is perhaps primarily leading this regulatory architecture, but we will have a role for RBI, right? Because we will have, because there will be cross-border funds flow, there will be, especially again with the rise of, the exposure of financial institutions to this market. So your thoughts on this?
Right, Shanaz. That's a very topical point which you have raised, and I will try to give some clarity on that. But I'll again go to a point which Pramod actually made. Blockchain as a technology is something which holds huge potential, and in the Indian context, it's actually been taken to very large use cases scenarios. The banking sector is doing it. Pramod made a mention about it, registries. I'm aware of projects which are being used for land registration and transfer. In fact, imagine if the distributed ledger technology, which is the blockchain, is used, I could own a piece of land, let's say in Guwahati, and I can do the registration, let's say in Kanyakumari, and it will ensure that nobody else can do it other than Ganesh only, which is where that permission-based ability comes. So use of the technology is something which India has embraced. It's going to help along. In fact, I even dream of this cutting across sectors, even into the hospitality sector, maybe in the hospital sector where information about patients, information about health concerns of people are known. It could also enter into the legal judiciary where perhaps court cases, etc. And you can link previous decisions to this without having to go back and try to search. Anyway, but that is one side on the technology. Fortunately or unfortunately, this technology has been used for an asset. And as like Anu said, one doesn't know what is the underlying at all. NFT, the non-fungible tokens, which Anu said, is actually a case in point. Last year, nobody knew what it is. This year, everybody is talking about art as an NFT. I'm sure that next year it's going to be something else. For all you know, it could be real estate being sold in the moon. When perhaps SpaceX goes over and lands in the moon. The sky is the limit for technology. And what I like the way Anu said, it's something similar to gaming. So what is happening in the crypto world? Something which is scarce, there is an artificial scarcity created around it. And when artificial scarcity comes in, the cost goes up. And when the cost goes up, there is a lot more interest generated on it. And when a lot more interest gets generated, more people plunge into it. That's all fine from a market perspective. But whether it is good for an economy, the point, that is where your point is right. Let me just try to relate it to, let's say, stock exchanges world over. Today in India, I can participate in New York Stock Exchange. I can be as a person investing through the New York Stock Exchange on scripts which I think are good enough for me to invest and make profits. But there are certain frameworks under which I can do. There are certain monetary limits. These limits, people can question whether that is X is right or Y is right. But the point is, this is what, in the wisdom of the lawmakers, this is what India as a country has an appetite for. And citizens under the Indian umbrella can go up to this level. So there are exposure norms. There are methodologies under which you could do it because of the time zone difference which is there. When some country is sleeping, another country is doing it. And one of the biggest things which happens in frauds, I don't know whether you have actually seen, studies show most of the frauds happen from a country which is awake on a country which is actually sleeping. Because by the time you get up, the fraud is already over, money is already lost. It's too late to get it because technology ensures that money hops possibly n number of times, and therefore finding out the audit trail is difficult. So taking all this into account, my view will be a three-pronged bucket approach is what will ultimately come in. There will be, as I said earlier, a multi-regulatory space which will come in. There will be an underlying asset, which is what is going to be the base for all these transactions. And the underlying asset, again, you can call it an asset, you can call it something else through some other name, but it is going to be there. Whether it is going to be actually regulated by SEBI or by another independent authority, like Anu made a hint about it, these are things which perhaps the lawmakers will clarify and it will get codified. But the point is, it has to be something which is underlying. The Bitcoin as Bitcoin, nobody knows what is the underlying. Stable coins, of course, have an underlying because it is going by the money which, as Pramod rightly said. But one doesn't know whether the stable coin which is issued based is the dollar as an underlying is going to be accepted in China, because they may not be willing to accept a dollar as against Chinese yuan or a RMB. So that being the case, there are going to be a lot of unanswered questions when it becomes cross-border. Anyway, we need not worry about cross-border right now. We need to be looking at India. So to my mind, the second bucket which will happen is there will be a framework which will come in, and the framework will address three issues. One, we already discussed about it, which is ordinary citizen protection. Two, whether it stands the test of law from normal existing fundamental principles. So that will also take care. It should not be violative of any of the privileges and rights that a person gets. It should not, like we discussed in the previous panel, result in a huge amount of data coming in and that data being used or misused. I am aware of, I'll just make a small digression. I am aware of a case under the RTI. Information about salaries of government employees is actually being published on the website. I know of a particular sector in Mumbai where there is a group of people who go and they find out these are the lady employees in the state government, people in the rank of additional secretary, joint secretary, etc. They find out what their salaries are. They simply make a call to this person and saying, we know this much of salary you're getting. Unless you give us this much of money as something like protection money, we are going to attack you. Now, this was not the objective of the RTI. This was not the objective of putting the salaries in the public space. But this is what is going to happen. An unsuspecting, unintended result is what is coming, which the crypto has a potential to come in. So the second set of framework which is going to come in, whether you call it a regulatory framework or the legal framework, will actually address the issues relating to the environment around the crypto. That's the second one. And the third bucket will be a clear demarcation between what is having a fundamental base and then there is a crypto transaction, or which doesn't have a fundamental asset. Anu made a passing mention about central bank digital currency. There is going to be crypto-based digital currency as a medium of exchange issued by the Reserve Bank. The governor of Reserve Bank has made announcements. When it is going to happen, how it is going to happen, what it is going to cover, these are matters of detail which will come in, but that is going to happen. But that does not mean that every other crypto which is available can be used as a medium of exchange. It is like saying, I have, let's say, 100 shares of Reliance. Shanaz wants to sell her flat. I say that I will give you X number of shares to actually buy the flat. Between Shanaz and me, this may work. But then if Shanaz wants to transfer those shares to Anu, Anu may say, I don't want Reliance shares, I want money. So it doesn't meet the requirements of an acceptable medium of exchange. So the third bucket will be that, and I may be slightly tangentially off, but the main thing will be that it will not be treated as a medium of exchange. And since that will not be treated as a medium of exchange, all the other frameworks relating to assets will continue to be there. And we already made a mention about it. It could be SEBI, it could be any other regulator. So they will be regulating the underlying asset. I also envisage, because it is highly technology based, there will be a need to regulate the technology platforms as well. I don't know whether it's going to be the Ministry of Information Technology, which is going to come in, or the Software Technology Parks of India, or some other entity which is going to do its job. But that will be required because a 15-year-old can write a small piece of code and that can break into established, we have already witnessed it in the case of the Bitcoin. We cannot let the trust of people who use it genuinely go down. So that's another thing which is going to come in. So it's going to be something which is going to be very complex. It's going to be not somebody's dream to actually get entered into it, but the government has to do it. They will come out with it. And therefore, my gut feeling is initially there will be these multi-pronged approaches, areas which will get covered under the regulation, which will get fine-tuned over a period of time. That may not be the last one. We may be seeing many versions, many changes which will come in. And that is what I think will happen. In the interim period, I hope and pray that nobody loses out, especially the citizen, and if they don't lose out, then everything is hunky-dory. I'll stop with this.
Thank you so much, Mr. Kumar. Pramod, I'd like to kind of get your thoughts on this whole classification debate, and especially since I think we all are saying that crypto assets perhaps may not be used or be allowed to be used as a medium of exchange. But what about stable coins? The emergence of stable coins, I think, also brings about new issues. I mean, to an extent, it has compelled central banks to now seriously think about central bank digital currencies. So your thoughts on this?
So very quickly, the way I sort of look at both the landscape and how it's panning out, I think there are close to, I'm told, about 6,000 or so crypto assets, right? And of course, we confuse the public with using cryptocurrency, crypto coins, and so on. So let me just call them crypto assets. And in that, to me, I think the key point which I would say is that medium of exchange requires it to be elevated to a legal tender, and which I think no sovereign is sort of going to do to privately created crypto assets. So I think that is going to be a far dream, and which may not even get realized. Which then comes to CBDC as the actual alternative that I think central banks will want to put into vogue. Again, pilots will be undertaken. I've already heard Mass say that they've ruled out rolling out CBDC because they think that increasingly financial stability, which is also a priority for central banks, may not be capable of being maintained with the fastness or the speed at which digital transactions and digital currency might move. So stable coins, to me, again, it comes back to the simple thing of that. Why did we dispense finally with having gold coins or silver coins being used for payment? Because the intrinsic value of that asset became worth more over a period of time, and probably the carrying cost also sort of physically being able to carry those equally started impacting individuals. And the movement to paper currency was sort of a signal to that, right? That you could sort of go with that currency note and that would get accepted wherever it is presented. Most people actually look at, and to a large extent, the US dollar was centered and anchored with the gold conversion right up to early 70s. It was called the gold standard. And I think a lot of cries about the creation of crypto and Bitcoin particularly comes from thinking that central banks have loose monetary policies, that they pump in huge amounts of liquidity when the economy requires, and that leads to inflation and so on. Why I'm bringing all this to fore in terms of stable coins is that stable coins is anchored around a basket of currencies or a commodity itself and so on, which underlying I'm assuming you can exchange that crypto into. Right. So today, to me, we already have that in a form of, let's say, digital gold. Of course, the regulator SEBI came out and sort of said that its own intermediary should not deal in digital gold. And I guess one of the legislative changes which is going to happen is to empower them to regulate digital assets like this. So if I had to draw that parallel to stable coins, I would say as long as they are capable of being exchanged into that underlying, and have a value which is known at the time of transacting, people may use it for exchange. But it comes down to the same example Mr. Ganesh gave, right? Will you accept RL shares for a transaction that you want to do? So will you accept a crypto which connotes gold? or will you accept a crypto which connotes the US dollar? And in terms of if you have to convert it back, will it cross the borders and therefore will there be a FEMA issue? Will it stay in the country and how will it sort of get converted? I think all those sort of become the issues to deal with. And so, and maybe it is a related point that I wanted to go to. Many are talking about right now that maybe we can just amend the current regulatory framework and add crypto as a, let's say, a securities type, right? So SEBI can automatically get empowered to regulate it. To my mind, I think crypto has so many different aspects to it, including technology, including the fact that it can be without an anchor, without any underlying, and so on. It needs a special legislation just for us to know that what are we dealing with is not like any other financial asset. I think that is the simple reason which I would advance of saying by a separate law might be required. And of course, that it will be multi-regulatory system for it. Pretty much for the reasons we have talked about, that RBI, if it comes down to payments, if it is going to go cross-border and so on. And SEBI, if in case there is fundraising, investor protection, exchanges which permit dealing in these crypto. If there are close to 6,000 crypto assets, that's roughly the number of listed companies we have in the country, right? And I know that we've gone through a period in our stock market where we had vanishing companies which raised money from the public and suddenly weren't available, right? Which led to tightening of norms against merchant bankers. To me, the question here would be, who's going to be those merchant bankers who introduce these crypto assets? Will the crypto exchanges take responsibility for those if liquidity vanishes? If an investor needs to sort of come into that and wants to exit, how will that settlement be assured? I think these become all of the norms which require a separate treatment, so to speak, and which is why I would sort of leave that thought there.
Sure, thanks a lot, Pramod. And I think if I kind of echo your sentiments here, because of course, I think given the complexities around with crypto assets, the types of crypto assets that are starting to emerge, and the kind of concerns around it, perhaps it may not be feasible to sort of deal with everything under existing laws, and perhaps that's the reason why we have not really been able to do so far. Now, since you mentioned about this sort of a special legislation or a special framework or a separate framework for that, I just wanted, and since we are also in the process of thinking about, we're discussing about the bill of crypto asset regulation in India, what do you think should be some of the key features of this particular bill?
I think, clarity that the regulators can be those that are already in the situation, RBI, SEBI, and so on. Maybe even mandating an interregulatory commission or a committee which sort of can join. I heard Mr. Ganesh talk about whether Ministry of Information or Ministry of Electronics and Information Technology might be involved. I would think a joint committee like that is necessary. We do have a form of it in form of FSDC, but really I think here we are going to be transcending several different sectors, and technologists will be critical to how it is both seen and reviewed and acted upon. I think the second category, as I said, are the exchanges, and are they going to be the gatekeepers? Are they going to be the equivalent of, like I said, merchant bankers who introduce a company to the public? Are they going to do that for crypto assets, or will we have another class of intermediaries created for that? Who will vouchsafe and bring about disclosures about what that currency means, what that crypto asset means, what can be the hard forks that can occur, how is it actually minted, and what is the limit? Like a Bitcoin has a technical limit, but let's say a Dogecoin, a meme currency, actually has no limit. So it can be minted to whatever extent one desires. How do you explain that to the investing public? That it might not therefore be, anti-inflationary like the Bitcoin author put it, in certain categories. There can be hard forks, which means a turn in how the currency, how the crypto asset is unfolding, which if it is by majority of those voting who can do it, right? To me, is that the equivalent of corporate democracy that we want to export there and sort of say that yes, there has to be a voice to the crypto holder in India, which sort of allows them to also decide, or that there is an exit offer, just like companies which are going for delisting, have to compulsorily offer. I think all of these sort of come to my mind as the immediate sort of thing. But most sort of important one which I would like to emphasize is that it's the wide prevalence without a regulatory framework which makes me nervous. That indeed, if the values go down and people lose their shirt or lose their hard-earned income, they will be held to pay. I think it needs to be made very, very clear that regulatory coverage will not mean underwriting or a safety net for these investments. Just like a SEBI cannot assure you that indeed your stock market will give you returns. You will get the returns what the market gives you, and that return might be negative too. I think I'd like that to sink into the investor consciousness. And maybe to begin with, it might even be advisable to sort of limit this to people who can take risks, right? The sophisticated investors, as SEBI sort of has brought about for various asset classes, including AIFs and so on. It could be a way of at least safeguarding, I would say, the lay public. There will be enough and more opportunities, I feel, for people to participate and grow with this asset class, provided we get it right. I think both in regulatory mix, in terms of what, how we classify, how we, sort of pan it all out. But yeah, for the moment, I would say I continue to watch with fear more than anything else, because one has seen Indian public losing money to plantation companies. They didn't understand what it meant. We didn't, as regulators or the system, understand what it meant until the tide went out, until people lost money. We are equally, accused of mis-selling financial assets, which we probably do understand. And I'm saying, if that is the kind of public sentiment which happens, both about financial assets, this is an animal which I don't even think they understand. And therefore, when I read that there are more than 6 million investors, or there are this much value which is accrued inside those, I am actually very, very scared, is the way I would put it.
Sure. Thanks a lot, Pramod. I think I completely agree with you in some of the points that you have raised, especially on how an interregulatory approach perhaps is required, because I think cryptos has now kind of shown that this sort of sectoral demarcation that we have created perhaps doesn't really work well insofar as this regulatory framework is concerned. And secondly, I think a lot of debate has been going on in terms of which are the players we want to regulate. And given the fact that there are multiple players spanning across jurisdictions, which might not be possible in the first row of legislation to sort of regulate. I think at the end of the day, the gatekeepers, the service providers will be the ones who will have to sort of be looked at. So moving on to you, Anu, I think one of the biggest concerns I think that governments or policymakers have raised around this is around how they may be used for illicit financing, national security concerns. To how, especially given the fact that there is a cross-border element to it, how do you think the regulatory framework or laws can help address or mitigate at least some of these concerns? I know I think you're on mute. Sorry, still not able to hear you. Maybe Mr. Kumar, I'll kind of come to you with this question in terms of, the challenges and concerns around illicit financing, how perhaps laws can be given, and also I think we might have multiple laws, but how do we sort of ensure enforcement challenges in this sector?
Right. Yes, Shanaz. I'll take the question now. This is exactly becoming like a crypto exchange. You don't know the other person, and then you stand up for that person and talk. But anyway, jokes apart, Anu and I share similar thoughts, so there's no problem. I can very well lead what he would at right time. The biggest challenge in the crypto scenario, as it is today with the private cryptocurrencies or private crypto assets, is anonymity. And that is what is a big concern for the fund usage or usage of this technology for, like you hinted at, nefarious activities, terrorism, and other type of activities which the government or the regulator may not be very comfortable with. So, how will this be taken care of? This will go by typically the two fundamental principles which are there even today in the financial sector. One, which is basic and over which I think there's a lot of debate, one doesn't know how it's going to pan out, is know your customer. In other words, if there is somebody who is originating a crypto transaction either as a player in the crypto exchange or a crypto exchange, or I will even say a person who is originating a cryptocurrency. Let's assume that India also starts its own crypto assets and provides for a system which does it. So all these three will have to be known very well to the financial intermediary which is actually going to facilitate the transaction. So the first one will be related to knowing the customer, on which there is fair amount of clarity, whether it is good, bad, right, wrong, simple KYC, etc. All those are matters of detail, but that's something which should happen. The second thing, sorry, Anu, I just stepped in your shoes. I will give back. I'll hand over back the control to you. The second aspect, which I think you're still not audible, just check once again. The second aspect which will come in is the need for traceability. Why there will be no entry into certain personal or confidential or sensitive information, trackability of the transaction where there is a need. So if the government feels that there is a particular sector or a particular transaction or a particular person who is suspected to doing this, subject to legal backing and being asked for by a person who is of repute, like a police officer or things of that kind, the law should actually state that where it is possible there should be trackability. Now this is easily said but very difficult to do, because if it is something within India, the law can say this is how it shall be done, and the system providers, exchanges, all the people can follow it. But when it is outside the country, our law may not even have a territorial jurisdiction over this, so it's very difficult to do this. This is where the role of intergovernmental cooperation comes. In fact, I don't know, some of you must have heard the Prime Minister talk about it. Of course, he didn't make a mention about it, but this is a concern that as nations, because I've been associated with other central banks world over, this is the fear that they have. Because India may pass a particular law, but if Pakistan, I'm just giving that as an example, a neighboring country doesn't have a similar law, and if the transaction were to be routed through that nation, you will not be able to make headway, and therefore usage of these will very well happen. So that's the second approach to be there. The third, which is a typically restrictive license Raj type of approaches, the regulator or the law, whichever it is, will say only these type of crypto transactions are allowed, or only these crypto currencies or crypto facilities are allowed, etc. The third one can be an approach, but in my view, that may not take off. India is far too mature to go to that level, so I don't think that scenario will actually happen. So to my mind, what will happen is 1 and 2, and perhaps, because technology is also evolving, there are tools in artificial intelligence and big data analytics which are coming in. Maybe technology will also try to provide solutions to these, meaning it can provide, based on certain rules, whether these transactions are genuine or these transactions appear to be suspect. Technology itself can be building in, and this technology can perhaps provide inputs to the lawmakers, to the law enforcement people who can try to take it forward. I'm not too sure whether Sanas is there or not. I don't know between Pramod and I think Anu has come in. Maybe one of us will have to take the job of the anchoring. So my point is, to this limited extent, this is what I feel will happen. I'll now hand it over to Anu so that he can respond whatever he had in his mind. Yes, Anu.
Sir, can you hear me? There seems to be some issue with the audio. Can you hear me? Great.
Go ahead. We could hear you. Yeah.
Great. So I was thinking about the anchor, so it wasn't just my connection. And gives me safety numbers is always good. Just one point on this. I think what really worries me with any new framework, and it's how Mr. Kumar was seeing this far closer. By safety, not perfect, future. But let's just look at, say, competition transition. Let's just look at NCLT. Let's look at it on tribunals. The challenge to dealing any new regulator is first you have challenges in terms of members, judicial, technical, non-judicial. Then always challenges on the composition. Somebody will go to the Supreme Court, High Court saying it's unconstitutional, which takes you 2 to 3 years to, because still there is a challenge pending. You can't really get the tribunal or the authority functional, because then whatever decisions they take is always up for challenge. The whole issue I see because if you look at conduct laws which have come, competition, for example, or data protection in the future, you can afford delays because of whatever reason by 4, 5, 10 years. But we are at a point where, if from this moment, if the authority is created, if it is a new one, for example, or even if you think of a SEBI, because it's not like magically overnight SEBI will come out with something which will regulate cryptos. Even if they have to apply existing conduct rules, be it front running, be it insider, be it onboarding, it's not a pari passu, so to speak, right? They can't just FMC integration itself took 2-3 years, if you recall, right? Now I don't know if after 3 or 4 years, given where we are in the whole crypto debate in the country and customer protection being the key theme, whether situation will be better or worse, or where it will be after 3-4 years, given how fast it is moving. There was a question Shehraz had asked me on governance. I'm not sure if she's still back.
I am back. I'm hearing you. Some problem with my video. Sorry, but please go on.
No. I have the same issue. Glad we are in the same bucket. On your governance point, cross-border national security, I mean, look, at some level, you have exchanges in the country, right? Since SEBI was created after the Harshita scam, so there is almost 3 decades of experience in terms of how to regulate exchanges, and close to 5 odd years of experience on how to regulate commodity exchanges. So ultimately, it is KYC, it is AML, it is ensuring that there is a trail, right? It is ensuring that what's the worry? Today, I should not be putting in money, right, as part of any exchange out there and pay somebody for an AK-47 in Afghanistan. That's the whole issue, right? Cross-border. Correct. And take the delivery of it somewhere where it ought not to be delivered. But fundamentally, that's the whole issue. So, point I'm making is, at some level, entry, exit, if you can regulate that, and you regulate what happens inside the exchange in terms of conduct rules, prop trading, market manipulation, a very important point is now talk about supply. Like the Dodge price, you don't know how supply is regulated. In the securities world, there is data capital. A part of it is put out there in the market. How what the supply of the stock, common stock, which is traded is. So conduct and what happens inside the exchange, again, there is a lot of experience. Entry, exit, clearing houses, settlement, all that we know. It's just about knowing who will belly the cat, and then maybe belly the cat quickly, as opposed to letting it run its course over the next 3, 4, 5 years, because maybe it's going to be too late by then. And definitely not looking at ban as an easy way out. Because the more I hear our analysts talk and the debate on this topic, if I were to put the hat of the government, given the where is the Everest base camp, and given all the various gradients involved to reach the Everest top on this, I mean, let's not lie, right? It's bad. It seems the easiest way out.
Sure. Thanks a lot, everyone. I think we have almost sort of come to the end of this session. And I think some very interesting points have definitely have come up. And I think a lot of issues that we wanted to discuss have been covered. And I think what we essentially understand, I think all of us, is the fact that it is obviously not going to be sort of looked at as a legal tender. And this perhaps will discourage its use as a sort of a medium of exchange. In terms of regulation, I think what we essentially are saying is that, I think there's been a lot of debate and discussion around it. Perhaps the market has reached a stage where we need to now seriously think about regulations. In whatever shape and form, perhaps existing laws are not adequate to address some of the concerns. So let's think about a separate legislation. And in terms of regulators, as I think Mr. Kumar has mentioned, and others have also kind of echoed that, is that we might have to think about multiple regulator or multi-regulatory approach, considering that this is something which has sort of blurred sectoral demarcations, and also keeping in mind, I think, the evolving nature of crypto assets and its use cases. And I think interesting points about how we should regulate market conduct, about how we should think about regulating current players in the market, the entry and exit points of this. And I think also one important thing is Mr. Kumar sort of brought up was the fact of intergovernmental cooperation, because I think at the end of the day, a lot of us have been talking about it, and we will need countries to actually speak to each other insofar as regulating this evolving sector with emerging technologies. It's been a pleasure to kind of speak with you all, sort of a lot of points for me also to kind of look back and inform my research in this space. Thank you everyone for joining. Thanks a lot.
Thank you very much.
Thank you. Thank you again. And